Let's go to the transported docket. Courtney Atterburn for sentencing. Courtney Atterburn. Good morning. Are you Courtney Atterburn?
Arterburn?
Arterburn?
Yes.
Excuse
Yes,
me.
sir.
Were you born in 1995?
Yes, sir.
What are the last 4 years? What were the last 4 digits of your social security number?
7627.
You're here today for sentencing. You understand that?
Yes.
Your pretrial diversion was voided on August 17th, 2023. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
A PSI said you had 5 years pretrial diverted for a period of 5 years. It was correct. 3 years is correct, isn't it?
Yes, Your Honor.
Okay, so I'll sentence you to 3 years.
Your Honor, we would ask to make an argument regarding probation at this time.
Go ahead.
Your Honor, by way of background, Ms. Arterburn's case was one where she was terminated from drug court for having a romantic relationship with another individual. The testimony that the court heard was that was her only violation while in drug court, and other than that had done very well in drug court. We'd ask the court to take that in consideration and probate her at this time.
Okay, I'll take it in consideration. I'm not going to probate her. The drug court is a very crucial program, and for people to disregard and be able to walk away from it, disregarding the requirements in it, just depreciates the drug court and the seriousness of crime your client committed. So I'm going to censure for 3 years. And then we will consider a shock probation when she's eligible. Okay.
And Your Honor, one correction on her PSI, she believes she is missing some custody credit for when she had served in the Hardin County Jail on this case. So I just asked if probation and parole could look into that.
Yeah, I'll take a look at that.
Yes, Your Honor.
And if you can't settle that with them, you can bring it back to me.
All right, thank you.
Hope things turn around for you. Richard Burge. You got one of the real pens here or something? Just got this one. State Bank.
This is one we had done an agreed order on, Your Honor. Did you say Richard Burge?
I received these yesterday afternoon.
See here?
He is not, Your Honor, since we did the agreed order. I did want
You
the
you ever
jailer.
think that I might have to approve the agreed order?
And Judge, I can ask Ms. Wyatt to have,
I could just make things a lot simpler and stay over at Burkesville and let y'all do everything, you know? I don't like that. And especially if they get there late in the afternoon. You read it here. What was the violation he's accused of?
He was sent to ARC facility, left treatment on foot. I was preparing to proceed with the revocation when Ms. Hunter called me, and then I called Mr. Collins. And Mr. Collins tells me they've got him set up for long-term treatment. Is that correct?
Yeah, if he's eligible to go, Your Honor, he's going to go into a 6-month program in Monroe,
And
if the court allows.
that's the kind of way we were, Mr. Collins and I were looking at. That was his last chance. If he left there, we was going to move to the revocation.
What was the underlying charge?
He had a wanton endangerment and a trafficking case. He's one of these people that's been around the block for a while. He's
Yeah.
had 2 cases. And he'll do good for a while and then he'll have problems.
I'll just take that under advisement. We'll come back to it. James Bowe,
Your Honor, this is another, we had done an agreed order for him to be assessed by drug court. I can ask Ms. White to have him on. I did ask them to not transport him simply because I was concerned, since we were going to have to reset him next month for his drug court assessment. It may not have been a valuable use of the jailer's resources.
Ashley Dubry. Commonwealth versus Ashley Dubry. Thank you for being here, Miss Dubry.
Thank you.
Yeah. This is 19 CR 0094, 19 CR 00101, and 23 CR 0017. Were you born in 1999?
Yes.
Last four digits, social security number 1926.
Yes.
We're here on a probation revocation on the 219 cases. And on 23, we're here on a pretrial conference.
Yes. We have an agreement, Your Honor. Approach.
What kind of agreement is it?
It is an agreement for time to serve on the 23 CR case, and then on the
She entering a
219.
plea?
She is, Your Honor, and she will be stipulated as a violation on the other cases.
A motion has been tendered. Just keep that over there. She'll have to identify her signature. A motion has been tendered that says you wish to enter a plea of guilty today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 23 CR 0017?
Yes, Your Honor.
Is your judgment impaired today?
No.
Have you discussed this charge with your attorney and are you satisfied with her advice?
Yes, Your
Have
Honor.
you viewed the evidence Commonwealth has against you? Do you believe you're fully informed about your case?
Yes, Your
You
Honor.
understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury. Right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. And the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, Your
I may consider the Commonwealth's recommendation. I may apply any range of sentence allowed by law. I don't have to accept it. Prior to accepting a recommendation, I will await a pre-sentence investigation report. Now, is your client a state prisoner?
No, Your Honor, but she will be once her probation is revoked.
No, that's true. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea. Now, what is the Commonwealth's recommendation?
Your Honor, Ms. Dubry will plead guilty to wanton endangerment first degree. She will receive a sentence of 3 years to serve. That 3-year sentence shall run consecutively with Monroe indictment numbers 19 CR 101 and 19 CR 94, which are both 5-year sentences, which would make a total of 8 years. The defendant shall receive credit for time served. She will stipulate to the revocation in 19 CR 101 and 94. The Commonwealth opposes probation. Any evidence in this matter be destroyed.
Is that what you agreed to?
Yes, Your Honor.
Okay. Are you pleading guilty because you did commit the acts charged in the new indictment? Are you pleading guilty because you did commit the acts charged in the new indictment?
Yes, Your Honor.
Okay. Knowing your constitutional rights, is it still your desire to allow the court to enter the punishment? You understand that any future convictions you might have could be enhanced under the persistent felony offender law. Do you understand that?
Yes, Your Honor.
Okay, is that your signature on the document?
Yes.
Okay, if you'll retrieve that, Mr. Bailey. I order a pre-sentence investigation report to be done by probation and parole and have sentencing on October the 19th.
Your Honor, she asked if, since she will become a state prisoner once you have signed the revocation order, if she could be sentenced today, as she would be eligible via statute.
How long has she been in jail?
Your Honor, she was in drug court. I'm not sure how long she's been in.
I'm gonna have a pre-sentence investigation for it. Okay. Okay, Destin Gentry. Are you Destin Gentry? Okay, were you born in 1997?
Yes.
Last four digits, social security number 3730.
Yes.
You're here on 19 CR 0082.
Yes.
Pretrial diversion revocation. What does the Commonwealth have to say?
Now, this was before the court 1 month ago, and the court entered a referral to the drug court to be assessed. He's eligible. My understanding, he was voted in this morning.
Okay, well, I'll, as soon as he has his schedule for orientation, I'll sign an order letting him out then. Go to drug. Janisha Howard. It's 18 CR 00194, 18 CR 00184, Commonwealth of Kentucky versus Janisha Howard. Are you Janisha Howard?
Yes, sir.
Born in 1989.
Yes, sir.
Last four digits, social security number 8397.
Yes, sir.
You're here on probation revocations. What does the Commonwealth have to say?
Your Honor, Ms. Howard
You need to
has,
come around here, and Ms. Howard, if you'll scoot over to the left, thank you very much.
has 2 5-year sentences. She was placed in drug court in lieu of revocation. She was terminated from drug court on August 21st, 2023. On January 28th, 2023, she missed a drug test. April 8th, 23, she missed a drug test. April 16th, Judge Costello issued a failure to appear because she was missing. And then she was terminated from drug court on April the 8th because she absconded from the program.
Runner, she would stipulate to the violations. I do want to put one correction. She was served with the warrant on May 10th and has been in the Barron County Jail since that date, and has about 122 days in. We would ask to stipulate to the violations that make arguments in lieu of revocation at this time.
Go ahead.
Your Honor, we would ask we would ask that this serve as a sanction with the court to have her probated with any additional conditions the court would place upon her. She has a considerable amount of time in on this sanction at this time. It would ask the court to consider that.
How much, it's a 5-year sentence?
It's a 5-year sentence, Your Honor.
How much time does she have if all that counts? Probation, parole?
I'm not sure, Your Honor. I have to look, I have to go back to your case on my computer and look, see how, what you have.
Maximum she'd be parole eligible after a year, and
Well, that's one thing. She's almost got that in, doesn't she?
the Commonwealth would be opposed to a sanction. I mean, if she was in drug court, that's the best program the state avails a defendant of, and she wouldn't participate. That's basically the reason she was terminated. So I don't know what's changed.
Judge, I think what has changed is she was kept in jail from May until this time, so it's given her a considerable amount of time to consider what occurred. And it is a considerable sanction prior to coming before the court on a revocation action, and ask the court to take that in consideration.
Well, I'm gonna revoke her probation. I think it would be in her best interest just to go ahead and get that year out of the way, and then you'll be on parole and you won't be on probation. You'll have to fool with this sort of situation. That's what my ruling is going to be. Justin Hunt. Justin Hunt. For sentencing. Commonwealth versus Justin Hunt, 23 CR 0033. Are you Justin Hunt?
Yes, sir.
Justin Darrell Hunt?
Yes, sir.
Yeah, you born in 1980.
Yes,
Last four digits, social security number 3108.
sir.
You here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report?
Yes,
Is it substantially correct, Mr. Hunt?
yes, sir.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Plead guilty to unlawful taking disposition more than 1,000, less than 10,000, 2 counts and shall receive 5 years on it. Each count to run consecutively for a total of 10 years, serve 180 days in jail, balance probated for 5 years supervised, shall continue, the probation shall continue till all restitution is paid. court lost the amount of $240. You need some time to pay that. I'll let you pay it at 30.
Jail for a while longer.
He has an alternative sentence associated with this, Your Honor, that he has not completed yet.
Well, I'm not going to make him pay it till after 30 days after he gets out, and then you pay it $30 a month. Okay. How many days? 180. 180 days. is it?
How much left, Justin?
I got 117 in.
He is 117 in, Your Honor.
Okay. Thanks very much. Gary Mosby. Well, thank you very Gary Mosby, 17 CR 0011. Hello, Gary.
Good morning, Judge.
You born in 1959. Last four digits, social security number 6667. Here today on a shock probation revocation. What does the Commonwealth have?
He has a 7.5-year sentence, Your Honor. And basically, the allegations in this motion are that he absconded and quit reporting. I need to call the officer. He's on the Zoom, Mr. Cowles.
Okay, officer, you raise your right hand. You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do, Judge.
State your name and with whom you're employed.
Ryan Cowles with the Department of Corrections, Probation Parole District 3, Bowling Green office.
Doctor, you don't inquire.
Yes, Mr. Cowles, how long have you been supervising Mr. Mosby?
Just a little over a year at this point, sir.
Okay, and what is the violations and recent violations Mr. Mosby has had?
Yes, so previously, this report was written in July 20th of 2022 for absconding. States that on May the 24th, 2022, Officer Kevin Etheridge attempted to contact Mosby at his reported telephone number in regard to him still needing to turn in a report sheet for May. He was unable to leave a voicemail advising him to call back, and later on that date, having not been contacted by the subject, he then attempted to contact him via his reported residence at Rosedale Rest Home, but was unable to leave a voicemail at that time. A letter was prepared and mailed to the reported residence instructing him to contact Officer Etheridge upon receipt of the letter on 6/2/2022 by 9 a.m. On 6/2/2022, Mr. Mosby did not report as directed. On 6/21/2022, Officer Etheridge received a report sheet from Mosby. It was not dated, but was stamped as received on 6/15/2022. The report sheet noted the same address of 415 Sutton Lane, Owensboro, Kentucky, which is the Rosedale Rest Home. Also received that date was the letter mailed to Mr. Mosby on 5/24/2022, sent back to the office as returned to sender, not deliverable as addressed. On that same date, it was noted that Mr. Mosby had reported an email address on the report sheet turned in for March. An email was sent to Mr. Mosby for him to contact Officer Etheridge immediately and to report on 6/28/2022 at 9 a.m. He did not report as directed. On 7/6/2022, Officer Etheridge received a June report sheet from Mr. Mosby, still reporting the same address. A new letter was prepared and mailed to the reported address instructing Mr. Mosby to contact him upon receipt of the letter and to report on 7/14/2022 at 9 a.m. On 7/19/2022, the letter mailed to Mr. Mosby on 7/6/2022 was received back as return to sender address, not deliverable as addressed. On that same date, a home visit was conducted by that officer and Officer Burden to Mr. Mosby's reported residence at 415 Sutton Lane, Owensboro, Kentucky. The Rosedale Rest passing sign on the front door and the building appeared to be vacant. The front main entrance was locked and there was no vehicles. It was evident that the facility was no longer off. Nevertheless, they left a green door tag on the front door instructing Mr. Mosby to report by 7:20 at 9 a.m. On 7/20/2022, Mr. Mosby did not report as directed. He did not contact his officer. A check of just exchange was conducted in the local hospitals, yielded no results at that time. Whereabouts were unknown at that time. And then going forward, he was at some point picked up on that absconding. I don't have Green office. And then since that time at the Bowling Green office, he's had a violation report for the use of methamphetamine. On 7/13/2023, Mr. Mosby was drug tested and field tested positive for methamphetamine. He denied use and the sample was sent to the lab for confirmation. Lab confirmed that he was positive for methamphetamine with a level of 4,205.6 nanograms per milliliter. Cutoff on the lab test is 50 nanograms per milliliter. He continued to deny use even in the face of the lab results, becoming uncooperative while doing so. He just wouldn't absolutely refuse to believe that he had tested positive, even though the lab had confirmed it. And while this doesn't necessarily raise to the standard of a violation per se, I think it does, this next thing I'm about to say does kind of contribute to Mr. Mosby's just general non-compliance, which is that on 8/8/2023, he reported for his scheduled report day. He had been utilizing the transportation program for transportation to the office for his report days. After his report day was complete, he asked if I could call the transportation company so that he could get a ride home due to him forgetting his phone at his home. I called the number listed on the transportation confirmation email and received an answer from Yellow Cab. The Yellow Cab employee advised that they were not assigned to his transportation request that date. I then sent an email to Vicky Tibbs, the customer service representative that handles our transportation request, to see if she could contact the correct provider. Vicky responded and advised that she had contacted Adaptive Enterprises to come and pick the subject up. Approximately 10:55, the driver from Adaptive arrived at the office. I believe he had walked off or gotten a ride with someone else. The Adaptive driver was notified and he left the property without Mr. Mosby. Later that date at about 1 o'clock, I received a call from Michael Montgomery, the owner of Adaptive Enterprises. Michael stated the subject had called their office and proceeded to curse at staff and threaten them. This was apparently over Mr. Mosby's return trip not being completed in a timely manner, according to him. Montgomery advised the subject made threatening statements and threatened physical violence against Adaptive staff members if they showed up to pick him up in the future. Specifically, Montgomery advised the subject stated that they, Adaptive Enterprises, were, quote, sorry sons of bitches, and that I'll beat your ass. Montgomery also advised the subject continually called staff at Adaptive, quote, motherfuckers. Montgomery advised that Adaptive would no longer be willing to provide transportation services for the subject in the future due to his statements. He was advised, subject was added to my caseload in September of 2022. And since that time, he's utilized the transportation service for almost all of his scheduled report days. And due to this behavior, threatening statements made toward Adaptive Enterprises, he will no longer be allowed to utilize the transportation services through probation and parole. If he needs transportation in the future, he will have to contact and pay for his own cert report that's prepared on August 9th of 2023.
I have no other questions.
Better may I proceed? Officer Cowles, when did you start to personally supervise Mr. Mosby?
It was September of 2022.
Okay. And at that point, he had already been to court regarding the alleged absconding in 2022, correct?
Yes, I believe so.
Okay. And that had been resolved by the court at that point, correct?
To my understanding, yes.
And you had noted that he had previously been at Rosedale Rest Home, correct?
Yes, that's correct.
Okay. And are you familiar that that had been closed by the state?
that was written in Officer Etheridge's report that when they conducted the home visit, it appeared the premises was vacated. Yes.
Okay. And so since September of 2022 until July 13th of 2023, he had had no other positive drug screens, correct? You did not know in your report any other positive drug screens, correct?
Yes, that would be correct.
And you,
The most recent. I'm
And we-
sorry, I couldn't quite hear you there.
okay. And probation and parole has a social service clinician available, correct?
Yes, they do.
And the social service clinician can evaluate defendants, whether they need any substance abuse assistance or mental health assistance, correct?
That is correct.
And as you noted regarding the transportation service, that is not an actual violation of his probation, correct?
Objection.
I think he testified to that, Your Honor.
No, but I believe it does speak to his, it's not a specific violation, but it does lend credence to his general unwillingness to cooperate with us or with people providing him free transportation.
Okay, and are you aware that Mr. Mosby suffers from some mental health disorders?
None that he is specifically provided documentation for me, no.
Have you made any
He's
attempts,
spoken of it, but he has not provided any verifiable documentation of that to me.
have you made any attempts to have your social service clinician assess him whether he's in need of mental health services?
He was scheduled for a SSC assessment on 9/7. However, to my knowledge, I don't believe he was available that day for
Are you-
that assessment.
Are you aware he was arrested prior to that date?
Yes.
Your Honor, I have no further questions for this witness.
No further questions.
I do have my own witness, Your Honor, if I would be permitted to
Okay.
pursue that. I'd like to call Bethany Steenbergen, my alternative sentencing worker. You might have the podium, Your Honor.
Okay.
Beth.
Raise your right hand. You swear to testimony that you is the truth, whole truth, nothing but the truth. State your name and who you're employed.
My name is Bethany Steenbergen. I work as an alternative sentencing worker for the Glasgow Public Defender's Office.
Ms. Steenbergen, are you familiar with Mr. Mosby?
I am.
Okay, have you worked with him in the past?
I did.
Okay, and are you aware of him having any mental health disorders that have been diagnosed?
I did. I had to get documentation to get him into the Rosenwald personal care home. They have to have a dual diagnosis for that.
And what are those diagnoses?
Paranoid schizophrenia.
And was this placement a placement that was structured to help him treat that?
It was.
And have you met with him recently?
I did.
Okay. And does he still appear to suffer from issues related to his paranoid schizophrenia?
Yes.
Okay. And are there options available to help him with treatment for that?
Yes.
What are those?
Mr. Mosby is very open to going to an outpatient situation to help with both his mental health and his substance abuse. I think he was trying to work on that prior to getting arrested. He also is working with Goodwill Industries, which helps for people who are disabled to get employment and work while they are out. They also help with transportation to and from those employment placements.
And does Goodwill Industry take into account the symptoms of his paranoid schizophrenia that may present itself?
Yes.
I have no further questions.
Any other witnesses?
I do not, Your Honor.
Any rebuttal?
No.
Go ahead.
Your Honor, I would like to note to the court that, and the court can take judicial notice of this, as we had a previous hearing regarding the alleged absconding in 2022. By the testimony you had heard at that time was the placement Mr. Mosby was in had been shut down by the state. and he had been told he needed to leave. After that time, if the court remembers, the court released him back onto probation. I think the testimony we have heard today was he had no issues until the positive drug screen in July. I know this court is very familiar with Mr. Mosby's mental health history, and that sometimes that does present itself in outbursts. I believe Mr. Mosby could benefit from some continued outpatient therapy. Perhaps he needs to look at a change in his medication management. And I believe that Goodwill Industries would also help him be productive in providing him supportive employment and assist in his transportation that could resolve some of the issues that Officer Coles said he was concerned about. So I'd ask the court to consider continuing his probation on the condition that he work on an outpatient treatment program and continue to work with Goodwill Industries.
Your Honor, with all due respect, excuse me, Mr. Mosby. Mr. Mosby may very well have mental health issues, but it's exacerbated by the fact that he will not stop using methamphetamine. And I don't see that any treatment's going to do him be of any benefit to him when he wants to self-medicate on illegal substances. I went back and looked through Mr. Mosby's file. He got a 7.5-year sentence on January 18th, 2018. He'd at that time served 219 days. The first motion to revoke his probation was filed October 18th, 2018, where he was arrested for possession of a controlled substance first degree. In lieu of revocation, he was given a sanction at that time. The second motion to revoke was filed on December 20th, 2018. It was renoticed to February the 21st of 2019, so Mr. Mosby could be picked up. He was charged with a DUI. He was supposed to go to life skills and didn't. He was in possession of that gabapentin and he absconded his probation. So this court revoked his probation on February 21st, 2019. He was shocked out on July the 18th, 2019. On the first motion to revoke shock probation, he failed to complete a program at the halfway house. He had set a fire at the rehab and he was kicked out. He was sanctioned. On the second motion to revoke probation, he had a conflict at the happy home. He wouldn't stay out of trouble. He was causing trouble. I think, to quote the people at the place, he had the whole place in uproar. He was throwing water on the cable equipment and set a fire in the backyard. Then February 20th of 2020, in lieu of revocation, he was placed in this Rosewood home that eventually closed. Now we're here on his third motion to revoke his shock probation. In this case, he's using methamphetamine again, following his treatment program. So
Besides that, what is he?
other than that, so I rest my case.
Okay. Go ahead.
Your Honor, we would just ask the court to consider allowing him to remain on probation. I understand that Mr. Mosby has had issues. I will also note that Mr. Mosby suffers from some mental illnesses that we don't ordinarily see before this court. I will note he has had no new offenses since this last time, and I think could very well benefit from some outpatient treatment and perhaps some medication.
How much time would he have left on a sentence, probation, parole, or whatever his situation?
Around 10 months. 10 months.
Well, I really, I've always found Mr. Mosby to be pleasant and respectful when he comes here, but there's not much else I can do with him. I don't know what's going to happen to him when he finishes his sentence, where he's going to live. I do think he has some mental health issues. He had one guy that stood up for him at one time, let him live with him when he came in here. Then that turned sour at some particular junction. So I don't think I have any alternative but to revoke his probation and hope that folks can find a placement for him when he gets his time out of the way. Okay, thank you very much. Jesus Padilla.
Thank you, Judge. Might be excused at this point.
Yeah, absolutely. Yeah.
Thank you, sir.
Are you Jesus Padilla? This is 22 CR 00105, motion to revoke bond. You born in 2002. You don't have a social security number, do you? Okay. You want to bring this case, Who's bringing the case? Mr. Stockton or?
Your Honor, he's going to stipulate to the bond violation. He is not disputing the bond revocation at this time.
Go over it with me.
One, your first issue, he didn't appear in court when he was supposed to enter a plea. And then when the court issued a warrant for him, he was subsequently charged with another case of receiving stolen property, possession of marijuana and drug paraphernalia, which occurred on August 24th, 2023. I have the officer here if I need to testify.
He's stipulated to it.
Yeah.
What are you gonna do about the bond? You gonna try, who signed the bond?
These two young ladies back here are on the bond, and I told them since he's in custody, I just want the bond revoked and I don't want to forfeit their property. I think they've learned a valuable lesson from this scenario.
Okay, well, I'll release you ladies. I would suggest you be more careful in the future. Yeah, we got some other people that need bonds here today. Y'all want to sign up today? That's what I thought. So I'll go ahead and release him the bond and revoke his bond. Where is he in the, did he have a trial scheduled or anything?
He did. I think that there is a new indictment that is going to be coming related
There's some
to.
additional charges been presented to the grand jury today. So
Okay, well, I'll
possibly a
just
trial next month.
hold him without bond next month. We'll try to set a trial date. You want him on the negotiation day?
That'd be fine, Your Honor.
When is your negotiation day next month?
It is October the 13th at 9 a.m.
October 13th at 9 a.m. and his next court date is October the 19th. Thank you. Marlon Stout. Commonwealth of Kentucky versus Marlon Stout, 23 CR 0007. Are you Marlon Stout?
Yes, sir.
Okay, this motion is set for trial. Were you born in 1995?
Yes.
Last four digits, social security number 8009.
Yes.
What do we have, Mr. Stockton?
He is co-defendant with Dustin and Jesse, and I'd like to get that case set for trial. And also,
Mr. Jesse is out of custody. Who is here?
he is.
We tried to send you guys some dates too, and those dates didn't work for anybody, so it was easy for somebody to on this time.
Commonwealth versus Dustin Jesse, 23 CR 0010. Are you Dustin Jesse? You were born in 1991.
Yes.
Last four digits, social security number 0707. Okay, how many days is it going to take to try this case here, you think?
1 day.
What about October 10th or 11th?
So we originally had it scheduled.
Do what?
That was when we originally had it scheduled.
Why did we have to continue?
And stop.
No,
Big.
the victim is gone on vacation.
November 7th, election day.
Yes.
So we can't do it on that day.
I've got federal court that day.
On election day?
Borough Barnett, yeah.
What about November 14th or 15th?
I can do that, but I'll need to do a federal teleconference at 2:00.
I believe Ms. Hill is available that day from what
You have to do what at 2:00
Federal teleconference, phone conference with the judge.
on the 14th?
Yes.
So let's do it. Let's do it on, how about the 15th?
I can do that.
What charge are you gonna try him on here?
Be the fifth unlawful taking, receiving. Company PFOs.
Okay. 15th. Addison Bryant. Cromwell versus Addison Bryant, 23 CR 0035. Are you Addison Bryant? Be born in 2004. Last four digits, social security number 8190. You're here on a pretrial conference. What does the Commonwealth have said?
We have a proposed pretrial diversion, please.
Motion's been tendered, says that you wish to enter a guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Are you the same person named in indictment number 23 CR 0035? Is your judgment impaired today?
I'm sorry.
Is your judgment impaired today? Do you know what's going on here?
Yes, sir.
Okay, have you discussed this matter with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case? You understand that you do not have to enter a guilty plea today.
Yes,
You have certain rights under the Kentucky and the United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have a right to speedy trial. You have a right not to testify against yourself. You have to be represented by counsel. You have a right to be confronted, cross-examine all witnesses called to testify against you. You have a right to produce evidence, right to call witnesses in your favor, right to fill this matter, right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charge against you. You understand by entering a plea today, you give up those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In the event they don't accept the recommendation, decide to impose a different or harsher sentence, you have the right to withdraw your plea and proceed to trial. Do you understand that? I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
I'm sorry.
Have you previously been diverted in the last 5 years?
No, sir.
You have any felonies in the last 10 years?
No, sir.
And are you currently on probation?
No, sir.
You understand that if you complete the diversion program, the charges will be dismissed pre-trial diverted. You can have your records. You understand that?
Yes, sir.
If you do not successfully complete the diversion program, you'll be brought back to this court and schedule a sentencing hearing. You understand that? Step to your left here and listen to what the Commonwealth has to say and see if this is what you agree to.
Upon a plea of guilty to wanton endangerment, first degree, 2 counts, the defendant shall receive a sentence of 3 years on each charge to run concurrently for a total of 3 years, pretrial diverted for 5 years, diversion to be supervised. Defendant agrees to have no contact with John C. Wilson. The defendant shall either obtain gainful employment or do a minimum of 30 hours per week community service until employment is obtained.
Tell me what happened in this case here.
This is the case where the there was a dispute between this young man and his girlfriend, a third party, another gentleman. I subsequently found out his girlfriend's pregnant.
So he had a gun.
He
He
had a gun, fired a gun up in the air, that neither one of them can say the gun was fired toward them, but they heard the gun fired. And all parties, once it's resolved, we first proposed a year for a year, and the court rejected that. Now we're proposing 3 for 5.
Are you finished with the guns? Are you finished with the guns?
Yes, sir.
You realize you can't have any weapons on you during this time period. And if you do, it's not going to be mercy on it, you know. I'm as concerned about what has might have happened to you as anyone. Doesn't appear that you had any intent to kill anybody, but when you get a gun and start waving it around and you ask for people to read your mind on whether you're going to shoot them or not, you could have been shot. And then and now are you back with the girl now? And
Yes, sir.
you're not with her now, but you got a baby coming.
Yes, sir.
Okay, well, baby might grow up without a dad anyway if you don't live up to your responsibility. If you've been killed, he never got to know you. You understand that? I'm going to agree with this new recommendation, but you just need to forget the guns.
Yes, sir.
Okay, I'll sign it and need to meet with probation and parole over there. Make sure I sign that. Okay. I'm going to take a short break here. I'll be right back.
It's going to hold your case with the judge. I ain't gonna want to. He's not gonna do that. I'm not gonna cause any problems. He may not at this point. I motion, he just got a lifetime cheat.
We need.
So Stephen Bray, is he not on the document? Sorry. Sorry. No, you're good. First, yeah.
I'm sure you know that.
She was telling me that Stout was gonna testify. Yes. But I don't know if it's gonna be the case or not.
It's not, because he's been in there for a minute and maybe, let me see.
Are you?
Yes.
That's all right. Oh, y'all had a pretty good bus the other night. Oh, gotta love it. Keep your case, honey. I read that really early this morning. So
He'll still look good.
I typed it earlier. You read it.
Oh, yes.
Oh, not for Johnny. No. Yes, you could. I guess it was.
There's no limitation either or, so I feel like maybe not, but.
Clear them out.
They do. No, I just don't want to.
No circus magic or circus bullshit. Just say-
You just tell us to.
What's your next one coming up?
They just tell us to inform them if we are not done by one.
We were just talking about that. I left that case.
They assign me somewhere else. But I won't have time to, but let me check with them and I'll let you know as well.
We'll see if Ken can work his magic on this.
And I could-
What are you gonna do on the trailer? The trailer
I'm gonna
failed.
crawl on the
How busy
floor.
we get?
I'm gonna crawl on the floor. As long as I can distract them from the real truth, that's all.
I'm gonna file a motion in limine so you can't name all the jurors' names.
You should do that.
I think I'm going to.
Mike did that.
Who?
Mike Richardson.
No, I'm not gonna do it. I'm just gonna make
Being a
him
butt.
a fool. when you do it.
Yeah, he said I couldn't look at the jury.
Oh, no, that's.
Well, no, he didn't follow that.
I'm
He
just
he
gonna
basically
let
said I
him
couldn't
go
look
there.
at
I
the
said,
jury.
I don't know these
You
fancy
can look at
tricks.
Siri, but you gotta address the damn witness.
You can address the witness. There's no rule that says you have to look at the witness. Like, that's garbage. But Mike did that and I was so frustrated. I was like, you know, that's ridiculous. Why don't you just tie my hands behind my back? Hey, Jesse. The court can do it. So you can kind of stroke the court a little bit to get them to rein somebody in. And that's what Mike did. On Dustin, Jesse.
Could be 5, so I better.
Could you do 5 and
No, if I was my offer, I'd come not to PFO first.
Okay.
I just rather try. He'll get 20 if we try.
Sunday afternoon,
I mean, just stole the fire chief's trailer. I mean, it's not.
Right. Well, here's his thing. He wants some sort of work release, but once he's sentenced it, he ain't gonna get it.
He might be doing good.
Do we agree to let him serve 9 months?
Take more time.
Probably. And let him do work release. Can we do that?
He can serve up to a year.
Can we do serve 9 months and then do? Oh, yeah, that's right.
Did I tell you John's already?
If you want to make that offer, I'll take them. I'll sit back and make that happen.
No, he'll tell me if he'll take it. I ain't big
Okay.
away.
As soon as I get done, I'll go. So what's the higher number? 7?
Literally 3 days after.
Or 5 years.
I was like, what's up? And he's like, can I be completely honest with you?
He may just switch to
I was
5.
like, you need a
He
call.
might
She's like,
switch to
"What
5.
is my Texas?"
I'll tell him I'll push the.
And I took the video.
Stole a utility truck, John DeWitt, attorney was defending. And Rick Riddle, the sheriff at that time, had made a mistake on the VIN number and transposed 2 numbers.
You didn't know.
She said, "Sheriff, shit, missed these numbers. I didn't." He said, "Yeah, I had about 13 trailers stolen at that time. I probably did mess it up."
He's adulting for the first time.
That's what the jury did. The felony.
That's probably the best he could say.
I would have probably been asking.
Well, she asked for it.
That makes you.
She asked for it. You transposed him. Well, he explained why.
Yes.
Be better to do it now than do it later. I was hoping to separate from his friends.
I was hoping to get back and swim today, but that looks like.
Yeah, you gotta get my kids. So. Keep your fingers crossed, don't jinx us, maybe there's hope. Maybe. I gotta go tomorrow before I go get my kids, because mine don't have any soccer shots. Mine's not getting soccer shots. We're just using that. Well, that's it, we don't have, well, we've got soccer shots. But well, you should have just thought I gave it their coat. Well, you should have, because I needed black or red. Yeah, so I'm hoping one more has some. They did have some now. They did have.
That story on that.
I told that two-face and Lincoln.
I said that.
Yeah. They used to
I said,
survive
"Yeah,
there.
David, I said, John.
I don't know who likes it.
I said,
Let's come back, let's go back on the record. We have Crystal Emberton, is it correct? Yes. Crystal Emberton. Como versus Crystal Emberton, 23 CR 0014. Are you Crystal Emberton, born in 1986? You have to speak up, it's voice activated.
Yes.
You have some kind of speech problem or anything?
No, sir.
Okay, I can't hear you. You got to activate the microphone.
Yes, 1996, 4301.
Okay, this is a motion to set aside plea.
Your Honor, I think this is based on when she was assessed for drug court. She, I don't think understood the call of the question, noting she had a drug problem because she's been working a DCBS plan. So I think she interpreted it as she's not having active use at this time. I've explained to her when drug court says that, they really are wanting to know, do you have an addiction issue, which she now understands. So she would ask the court to allow her to be assessed again now that she understands it does not simply mean is she using it this time, but it is a broader question than that.
I have no objection if she wants to be reassessed and see if she can get into drug court. That was the reason I was leaning on the plea, was because she was going to enter the drug court program. If she can't go in, I'd probably rather just have a trial date.
What's the charge?
She had a DUI and a wanton endangerment because she had children in the car. And we entered a plea with the I assumed that she'd be going in the drug court as part of that plea. That's the reason I agreed to it. And it was a diversion.
And I think because she's been working with
You're gonna
DCBS,
have to speak up.
she has been working her DCBS plan. So because she did not have any active use, I don't think she understood the call of the question meant more broadly that does she have an addiction issue? She understands that's what the call of the question really does mean and would like the court to allow her to be reassessed.
Would she get 1 year pretrial diverted or what'd she get?
Oh, I think it was 5 to 5. It was 5 pretrial diverted for 5, and she also pled guilty to the DUI. And as part of that agreement, she was.
Now that she can't go to drug court, then she was going to serve the 5 or what?
No, I'm asking since it's diversion and she didn't complete part of the diversion, I was asking it to be set aside, but what they're wanting is to another shot at the apple to be reassessed. Another bite at it. And we've done that before.
Well, I guess it could have been said you wanted to revoke her pretrial diversion.
Yeah, I could have made that.
Yeah, I mean, because when he said motion to set aside plea, I thought, that's all I saw in it, so.
Yeah.
Well, I'll do another referral on that. And then if she doesn't do it, then then you can file a motion to revoke her pretrial diversion. Okay, thank you. Garcia, Como versus Marcelino Garcia.
Your Honor, on this case, I think that Mr. Bell's office submitted an agreed order on that to continue it to another date. He went in yesterday for a medical procedure. And I think that he actually was kept at the hospital, and so.
Okay. We'll continue it till, do you think he'll be available on October 19th?
Your Honor, I think there was a date in the agreed order. Yeah, for 10/19 it was. yeah.
Okay, thank you. Mary Gerald. Cromwell versus Mary Gerald, 23 CR 0038. Are you Mary Gerald?
Yes, Your Honor.
You're born in 1984.
Yes, sir.
Last 4 digits of social security number 2186.
Yes.
We're here on a pretrial conference. What does the Commonwealth have in this case? You have a agreement here?
We do, Your
Is it a
Honor.
pretrial diversion or a felony plea?
It's felony plea, I think, Your Honor.
Okay, a motion has been tendered, ma'am, that says you wish to enter a plea. Is that correct?
Yes, Your
Are
Honor.
you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
State your full name.
Mary Jacqueline Gerald.
Okay, are you the same person named in 23 CR 00038?
Yes.
Is your judgment impaired today?
No.
Have you discussed this matter with your attorney and are you fully informed about your case?
Yes, sir.
Are you satisfied with her advice?
Yes.
Are you pleading guilty today because you are guilty?
Yes.
Okay, you understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you fully understand those rights.
I do, Your
I'm
Honor.
going to go, well, I don't know that you do until I tell you what they are. So I'm going to go down and tell you what they are, and then I'll ask you, okay?
Okay.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, your right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that entering your guilty plea today, you give up those rights.
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. Prior to accepting the recommendation, I'll have a pre-sentence investigation report done by probation and parole. In the event I don't accept the recommendation and impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Do you understand that? There, Mr. Judge? What's the Commonwealth's?
The Commonwealth agrees to dismiss the PFO second degree 3 counts enhancement and upon plea of guilty of criminal possession of forced instrument second degree 3 counts, the defendant shall receive a sentence of 2.5 years on each count for a total of 7.5 years probated for 5 years supervised. The defendant should be referred to the social service commission following any and all recommendations. The defendant shall pay restitution in the amount of $616 plus 5% clerk's fee to Monroe Circuit Court at a rate of $100 per month, with the first payment being due within 30 days of the entry of the plea. The 5% clerk's fee shall be added each monthly payment, with the principal amount of $100 being distributed to the victim. Court costs shall not be taken from restitution payments. The defendant agrees to have any and all evidence destroyed in a manner consistent with laws of the Commonwealth of Kentucky. And that's it, John.
Is that what you agreed to?
Yes, Your Honor.
Are you pleading guilty because you are guilty of doing the acts and the indictment is amended?
Yes.
Let me ask you a little bit about this case here. What's the deal here?
I know here for don't want to say anything wrong. Evidently, the victim is Miss Gerald's aunt. They lived together at one time, and she was taking her checks and and forged this check or was in possession of it.
What are the previous felonies that she had? You had some PFOs. She PFOs.
She had an 18 CR 218 in Barron Circuit Court possession. And an 08 CR 20 Allen Circuit Court. She had another possession.
Drugs.
I was, based on what I knew about the case, I was wanting to put her in drug court. I wasn't able to accomplish that during the plea, so that might be down the road unless she stays clean.
This is going to stay in effect until the restitution is made. What it says.
It's 5 years probation. So
Just $1,600 restitution. Okay, well, knowing your constitutional rights, have I explained to you, is it still your desire to proceed with a guilty plea and allow the court to fix your punishment? You understand that if you get convicted of felonies in the future, that you could be PFO'd again. And that increases or enhances the sentence you can get, about doubles the possibility. Do you understand that?
Yes, I understand.
Okay, is that your signature on the document?
It is.
I accept the agreement. And or a pre-sentence investigation report. And the sentencing will come back here on October the 19th for your sentencing, okay? Leave a probation parole officer right over there. Courtney Mabry. Is it Mabry or Mabry? Mabry, okay. Courtney Mabry, 23 CR 0020. Miss Mabry, were you born in 1993?
Yes, sir.
Last 4 digits of social security number 9966.
Yes, sir.
You're on a pretrial conference.
Yes, sir.
What's the Commonwealth have to say in
we
this?
have it first.
Motion has been made that says you want to enter a plea today. Is that correct?
Yes, Your
Are
Honor.
you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes,
Are
sir.
you the same person named in indictment number 23 CR 00020?
Yes, sir.
Is your judgment impaired today?
No, sir.
Have you discussed this matter with your attorney, and are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you? Believe you're fully informed about your case.
Yes, sir.
Realize that you do not have to enter a guilty plea today. I'm going to go over your rights with you. At the end, I'm going to ask you if you understand them. These rights are under the Kentucky and United States Constitution. You have a right not to testify against yourself. No one can make you say anything. You have a right to be tried by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to pray the Commonwealth prove beyond a reasonable doubt that you're guilty of all the charges against you. You understand that by entering a guilty plea, they give up those rights. Now, I may consider the Commonwealth's recommendation, or I may apply any range of sentence provided by law. If in the event I do not accept the recommendation and decide to impose a harsher penalty, you have the right to withdraw your punishment, withdraw your plea and proceed to trial. Now, I'm going to ask some qualifying questions. Have you previously been diverted in the last 5 years?
No, Your
Do
Honor.
you have any felonies in the last 10 years?
She has one in Tennessee that is 8 years old.
She qualifies. The statute now says it has to be within the last 5 years.
I thought it was just diversion in the last 5 years. Yeah, it's a felony in the last 10 years, diversion in the last 5 years. Well, why don't you pull the statute out and see if it specifically says felonies in Kentucky.
The program may be utilized for a person charged with a class C felony offense who has not within 10 years immediately preceding the commission of this offense has been convicted of a felony under the laws of this state, another state, or the United States.
No, else.
Supervisor. Or the police.
Well, what's she charged with?
It's a possession case. This is one of these cases where I have to clean up the docket. Basically, she come up here and got a possession case. She goes to Tennessee. She's at Hope Ministries.
Hope Center Ministries, she's still there.
She's at Hope Center Ministries.
It's in Portland, Tennessee.
What do you do, young lady? What do you work somewhere?
It's a 12-month faith-based program, and I've been there 10 months. So I'm in my third phase. So yes, I do work now. I just started full-time Monday.
It's a rehab facility.
Well, or we can just continue the case till when you gonna be finished with your program?
It'll be, I graduate November 10th.
I'm gonna continue this case to December the 14th from another pretrial.
Okay, thank you.
So you come back up here and they'll present it, and he can make a motion and we'll see what happens. So yeah, it gives you another incentive to take care of this.
Yes, sir. Thank you.
Okay. Ashley Pedigo. Ashley Pedigo. There's an active warrant out there. Joshua Perry. There's an active warrant. Okay.
We've got a hold on.
Okay, Tiffany Spalding. Active warrant out. Alex Tooley. Homo versus Alex Tooley. 16 CR 0062, 18 CR 00140, and 22 CR 0039. chalk probation revocations and probation revocation. Mr. Tully, were you born in 1968?
Yes, sir.
Last four digits, social security number 3454.
Yes, sir.
Okay, you moved to your left here. What does the Commonwealth have to say about this?
None of this was brought before the court a month ago when the court gave Mr. Tilley the estate to pay $1,000. He's paid $600 and tells me that he can start working at the cookie factory in London. That's where he lives. And pay regularly at $150 a month. And I've got no objection to that as long as the probation continues until the restitution is paid in full.
That's the only problem. He knows not paying restitution or any other
Right now,
violation.
yeah, he looks like he's got his life in order rather than paying on the restitution. He looks like he's trying to take care of that now.
How much does he have left to pay?
I think it's like 15,000 since the part. He had never paid anything. He told me to pay 1,000. He told me this morning I was coming up the steps. He hollered at me, and before I could tell him I couldn't talk to him about the case, he told me that he paid $600 without even working. He'd scraped up that much, so and he's got a job Monday. So
I'd like a wage assignment on this. How much you gonna be making over there?
I don't know if I go back to regular, because if I don't have to, like before I went through Tim, and as soon as I got hard full time, I came to court and I got locked up from Bowling Green, stayed 31 days for a fine that had already been paid. So I lost my job and I went to job of working on for a farmer and I wasn't getting enough hours and I quit. So I'm gonna, I
You
should
already,
start off
have
around
they already
13.
hired you or you think you can get a
No,
job?
they said that they done a rehire on me. So they said that I should be able to start. I could have started this week.
I'm just asking.
Yes, sir.
I don't want to
Yes,
know
sir.
your life story.
Yes, sir. I could,
You go, when do you start to work over there?
when I go back, I'm supposed to call and I should start next week. As soon as I give them the call that I'm through with this
Well, I
court.
want verification that you have a job
Yes, sir.
and do a wage assignment. Okay, and he owes. So how much a month can we get off of him?
well, he said 150 now. The money increase.
You know, give you a motivation to live that long, because at $150 a month, it takes a while to get 15,000 or whatever it is.
Yes, sir.
Who else was jointly responsible for paying it?
I can't remember the co-defendant. I think he was a stepson of the victim, I believe.
No, I don't, Josh or
Does he
Justin.
pay anything? Okay, well, that's a good thing. It counts off against yours too.
Yes, sir.
So I want $150 a month wage assignment and verification to your attorney that you got a job over there and the wage assignment's been done. You can prepare the wage assignment counselor against you one. And just send those to Commonwealth attorney and you just be continued
Okay.
generally on that and stay under your probation. You report to probation parole officer over there.
Yes, sir.
Okay, good luck to you.
Thank you.
Michael Turner, active warrant, Michael Turner. Is there anyone else here that I haven't called your name that's here to come before the court live in person?
Just hand him that card, ask him to send a verification.
Michael Turner is in jail. He's on my list.
Okay, we'll move him down to the Barron County docket.
Yes, Your Honor. Thank you.
Is Richard Burge over there too?
Judge says we'll agree to it.
I know, but is he over there too in jail? Where is he? Who is the other with the so-called agreed order? Besides Richard Burge.
But
He's in jail too over there, right? Okay. Okay, well, we have, we'll go to Barron County in 7 minutes. Let's go off the record. Sure.
When you go to Barrett County, all Mr. Gardner has left and all I have is Brian Roberts.
You want to come up here now? What's the Brian Roberts case about?
The Brian Roberts case is an assault first case, it was indicted as, and he is actually being held in custody for drug court violation. And last time we were here, some confusion about whether I'd be handling that or Jesse.
So we're actually going to handle it. And,
The revocation.
The revocation, correct. I'm still handling.
If
the
he
assault
brings it.
case. The assault case actually occurred before the offense of the drug.
Okay, are y'all ready to set a trial date?
We have had a conversation about settlement, and I think part of it's depending on how this is going to shake out with the drug court.
He was violated 90 days ago, but we only got the notice of violations.
Mr. Stark and I talked about it several times, so we're hamstrung on trying to resolve this one until we know what's going to happen.
How much, what resolution do you want to that food? So,
Well, I want him to dismiss his case. Of course, that's the resolution I prefer.
well, that's the reason I think that we might just go ahead and set a trial date today.
If that's what
Okay, Barron County Detention Center cases. Commonwealth versus Byron Roberts, 20. Byron Roberts, 23 CR 006. There they are. Are you Byron Roberts? Okay, I think you have two cases here today. Is that correct? You hadn't filed your case yet.
No, I just received the information to file.
Okay, Mr. Roberts, we're here in 23 CR 006. Were you born in 1992, Mr. Roberts?
Yes, Your Honor.
Last four digits of social security number 7584.
Yes.
We're here on a pretrial conference. Mr. Gardner's here as a special prosecutor. Mr. Gardner, we had a discussion with you and defense counsel during the break. Do you have anything that you'd like to announce?
Your Honor, just that I had discussions with Mr. Cross about a resolution of this case. There is, obviously, there's another action. There's motion filed in that action. It might be outcome determined of our case. And so.
Mr. Stockton was here also and is present now within our hearing. And I think there's a motion on revocation on another case. Is that right, Mr. Stockton?
Heard next month.
To be heard. And so, Mr. Roberts, what's going to happen, your attorney's here is in discussion with Mr. Gardner, and they're going to wait to see what happens on this revocation before they can determine what they're going to do on your case. So we'll continue this case until October the 19th, and maybe they can wound them all up at once. You understand that?
Yes, Your Honor. Thank you.
Okay,
Your
thank
Honor,
you.
if I may briefly address the court, Mr. Roberts was arrested about 90 days ago on a drug court violation. I'm just, and it's not Mr. Stockton's fault, but I'm bewildered as to how it took 90 days to get this done. And
Mr. Cross, I'm bewildered too.
well, and I said
To get
yesterday.
what- to get what done? We hadn't done anything yet.
Well, I mean, he's just, I said, if I hadn't done a habeas corpus in 35 years, but I was thinking about doing one because I feel like there's been a due process issue.
Well,
All that being said.
here's the thing about it is, we're here today on 23 CR 006. Now, why hadn't it been brought here before?
Well, Your Honor, we can't settle that one until we know.
Well, I mean, it's a determination you've made that you can't settle. You could have brought this case on and we could have set it for trial and moved it on. What you're doing is trying to get an advantage to wait to see what that's doing. And I understand that, but that's not Mr. Stockton's fault. Some things are Mr. Stockton's fault and some things are my fault. Nothing's ever your fault.
I'll take my blame and-
I understand you're advocating for your client. So, and taking that in consideration on, when we come back up here on October 19th, if y'all have everything ready in agreement, we can end it on that day.
Thank you. Your
Okay,
Honor.
thank
That's all
you
I
very
have.
much. Okay. Yeah.
There's nothing else case on this stuff. Person needs one, the clerk.
Okay, which case is that?
Robles.
Ablin Roca,
No, Robles.
Robles, Jose Robles. We have an interpreter here. Is the interpreter here? Was there? If you excuse the interpreter?
Not your
I
own.
thought maybe you did.
But I will tell you, Mr. Robles, he is, I believe, a United States citizen and does not need an interpreter.
Okay. Commonwealth Kentucky versus Jose Robles. 23 CR 0050. Are you Jose Robles? Hello? Can you hear me, sir? Jose, can you hear me?
Yes.
You're here on 23 CR 00050 for the purpose of arraignment. Were you born in the year 2000?
Yes, sir.
Last four digits of social security number 4313. Is that right?
Yeah.
4313. You have a right to remain silent. You're represented by the Office of Public Advocacy. They're here. The grand jury of Monroe County has returned an indictment charging you with criminal attempt to murder, assault in the first degree, murder. And there's an order amending the indictment that changes the UOR code only. Counselor, do you acknowledge your client's identity, receipt indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, and Mr. Stockton, I'm signing, and Mr. Robles, I'm signing a reciprocal discovery order that says the Commonwealth will turn over to your attorney all of the evidence they have, Mr. Robles, in your case. This is a complicated case, I guess, and so you want to sit it out a little while or what?
Because we don't have all the medical records yet. Defense counsel just now signed an agreed order that we're submitting for medical records.
Okay, let's try November 9th on this thing. And is there, what will your November negotiation date be?
I don't know yet. I would think it'd be the first Friday of November, as long as Miss Hill can be here, which would be at 9 o'clock. It'd be November the 3rd at 9.
Okay, I'll set a negotiation day on November 3rd and the next court appearance on November 9th. If you have nothing to talk about you can submit an agreed order showing that he doesn't have to be transported.
I was actually going to ask if I could contact Mr. Stockton independently. This will be my case as well as Ms. Hills, but I'll be lead, but I'm in Heart Circuit that morning. So if I could just arrange a meeting with Mr. Stockton, we are pretty good at keeping communication
That'd
with
be
each other.
fine. Okay, Dalton Birdwell. Dalton Birdwell. For sentencing. Are you Dalton Birdwell?
Sir.
Born in 1998.
Yes, sir.
Last four digits, social security number 5368.
Sir.
You're here today for the purpose of sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Sir.
Is it substantially correct?
Yes, sir.
Is there any reason not to sentence this gentleman?
Your Honor, we would just ask for the opportunity to make an argument for probation at this time.
Go ahead.
Your Honor, Mr. Birdwell is a very young man. He is asking the court to consider doing a referral for drug court. He would like the opportunity to have the structured environment to get clean. He believes that he needs the level of care that drug court could provide in terms of structure. I would ask the court to consider that at this time.
What's the Commonwealth have to say?
Your Honor, I would ask the court to impose sentence at this time, and I would be glad to look at that on shock probation. He was on probation for quite a while and he had multiple violations. He would do well for a while and then he wouldn't, but I think shock might be appropriate in this case. He would go to court.
Okay, I'll go ahead and impose a 5-year sentence and we'll consider any kind of alternative opportunity on a motion for shock probation.
Your Honor, I would make a motion on behalf of Mr. Birdwell's benefit. The paperwork that we did in the original plea, it should have had an amendment from a Class C to a Class D felony, and it didn't. I'd ask the court to sentence him on a Class D felony rather than a Class C felony. That would comply with the diversion.
Okay, that'll be fine. Just make note of that.
Lieutenant North.
Stephen Bray. Stephen Bray. Commonwealth versus Stephen Bray, 23 CR 0031, here today for arraignment. Are you Stephen Bray,
Yes, sir.
born in 1970?
Yes, sir.
Last four digits, social security number 0058.
Yes, sir.
You have the right to remain silent. Looks like you do not have an attorney. Did you have an attorney in district court?
Yes, sir. I had, Mr. Bryant Green, and, I was released on a OR bond to go to rehab, and I was currently.
Wait. Is that public defender's office?
Yes, Your Honor.
I'll continue the appointment of the public defender. They're here, they'll represent you, okay? I don't want you to say anything that could be used against you, Mr. Bray, so I want your lawyer to talk to you first. The grand jury of Monroe County has returned an indictment charging you with terroristic threatening, and also strangulation first degree. Counselor, you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, we have a date of October the 9th for negotiations, and October the 13th. Mr. Bray, I'm signing a reciprocal discovery order. Says the Commonwealth has to provide your attorney with all the information they have to help you prepare a defense. When do you think y'all be able to see Mr. Bray?
Your Honor, if he could, Mr. Stockton has approached me because Mr. Bray had been in long-term treatment to see if we can come to an agreement on bond. I have some Zoom dockets to do this afternoon, but if he could call me perhaps about 1 o'clock to see if I could arrange something for his bond.
Well, I mean,
I was more saying that for his benefit as
I
they have
didn't
my
ask you
cards
about the
there.
bond. I asked you when you could go see your client.
Your Honor, probably not till tomorrow afternoon due to my
Okay, your
docket.
attorney will be someone from your attorney's office will be over there tomorrow afternoon. And this is a strangulation case and an assault case. I'm going to have to hear something about it. You know, I don't want you to just like give me something and say that he's out, you know. Okay, they'll be over to see you, Mr. Bray. Jonathan Cole. Commonwealth versus Jonathan Cole. Commonwealth versus Jonathan Cole, 19 CR 00127 and 20 CR 0069. Are you Jonathan Cole?
Sir.
Were you born in 1996?
Yep.
Last four digits, social security number 1254.
Oh.
Yeah, we're here for a shock probation revocation on both those cases. What does the Commonwealth have to say?
This is actually, we have contracted this out to Mr. Bruce Brown. We are trying to get a hold of him. Would the court consider putting this on for the next month's docket as we are still trying to get a hold of Mr. Brown?
We could hear it in Cumberland County if the court wants to too.
What is this? Come around here and tell me what this is about.
This is the case, we revoked his co-defendant last month. This is the case where Mr. Cole and I believe Mr. Adams were down in Tennessee. And they were fleeing and evading a police officer down there and they had an ounce of meth on them. And so you revoked his co-defendant last month and I'll be putting on the same evidence again.
Is he being held on anything else here but that?
No, this has always been held on. So if the court wants a quicker hearing, I don't care to hear it earlier.
Well, I'll schedule it for October 19th, but if you're,
I mean, y'all gonna do what you're gonna do. I know what you're gonna do.
schedule it for October the 19th.
Thank you, Your Honor.
Stacy Eden. Comwell versus Stacy Eden. You Stacy Eden. Were you born in 1989? The last four digits of social security number 3700. We're here at 23 CR 0051 for the purpose of arraignment. You have the right to remain silent. You don't have an attorney, it doesn't look like. Is that correct? This go through district court.
Yes, sir. I had Green downstairs.
You had what?
The lawyer Green.
Do you have a public advocate?
Yes.
I'll continue that appointment. You have the right to remain silent. Your attorney is present here today. The grand jury of Monroe County has returned an indictment charging you with public intoxication and assault in the first degree. You hand that to it. Counselor, do you acknowledge the identity of your client receiving indictment, await formal reading, and any plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
So just for October 9th for negotiations and the 13th.
That might be too optimistic, Your Honor. We got to get medical records in this case too. It's a assault stabbing case. We're submitting an order to get the records of the victim.
If you don't have them by then and don't get negotiation, contact us. Okay, Keith Gross.
Your Honor, could Mr. Stockton and I approach on Mr. Rose's case?
It won't do good that you're being broadcast everywhere. Is there something you need to? Let's go off the record for a second. Wait a second.
You'll go on lockdown. This is the last time I'm gonna tell you all not to talk. If it's before you see the judge, we'll tell him you didn't conduct yourself accordingly in court.
This is Mr. Gross here. Mr. Gross, we had to go off the record just a second. It appears that your attorney has had some maybe severe medical problems here. And I won't go in consideration of his privacy. I won't go into the detail about it. So I'm a little concerned about his ability to represent you adequately because of these problems. So I've talked to the Office of Public Advocacy to maybe get you somebody else lined up here that can come and get involved in your case after they consult with him. So in consideration of that, we'll set a negotiation date on October the 9th and October 13th, and somebody from public advocacy or a new attorney will be over there to see you within the next couple of days, okay? Okay, thank you. Jason Pitcock. Commonwealth versus Jason Pitcock, 23 CR 0030. Are you Jason Pitcock? Born in 1982. Last four digits, your social security number 2853.
Yes, sir.
Presented by Mr. Ken Garrett here. We're at a pretrial conference. What does the Commonwealth have to announce? You want to come around?
Two things, Your Honor. We will need another pretrial. The Attorney General's office to go with evidence, and also I've been informed by the Attorney General's office, they're still going through additional evidence from another search warrant from Google, and they just now got the return on that. So we need at least
Is
30
this
days.
a pornography charge or something?
Yes, Your Honor. Child distribution and possession.
So when you want to,
We can set it for October or November, either one the court wants.
Well, let's
October
set-
may be optimistic.
let's set for October 9th. And then the next court appearance is October the 13th,
Not
19th,
Yeah, and October 13th at night. It's a pre.
October 19th, and then October 13th is the negotiation day. I had 9 AM under there, October 19th and then October 13th. Mr. Pitcock, they said the Attorney General's office has been in contact with your attorney. Is that right?
I've got to contact them and go through the evidence.
Okay, so he has an opportunity to go through the evidence. So we've set those new trial dates, those new court dates. Albine Roca,
That's Mr. Bell's client. He said he's representing him and he's not available today.
Mr. Roca, your attorney has had a medical procedure being performed. All these lawyers are having a rough time here. He had a medical procedure, and so we're going to continue review of your case until October the 13th for a negotiation day and October the 19th for your next court date. Okay, he'll be in contact with you.
Thank you.
Yeah, Patrick Scott for arraignment. Patrick Scott, Conwell versus Patrick Scott. 23 CR 0048. Are you Patrick Scott?
Yes, Your Honor.
You born in 2001? You born in 2001? The last 4 digits of social security number is 0480.
Yeah.
You're here on 23 CR 0048 for the purpose of arraignment. You have a right to remain silent. Do you have an attorney?
I had a public attorney in small court.
District court. Yes, the public advocate. I'll continue that appointment. You have the right to remain silent. Your attorney's present here now. You've been charged with operating a motor vehicle under the influence, wanton endangerment, first degree, 10 counts. You understand those charges?
Yeah.
Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, preserving all pretrial motions?
Yes, Your Honor.
Mr. Scott, I'm signing a reciprocal discovery order here, where the Commonwealth's turning the evidence they have over to your attorney. We'll have a negotiation date on October 13th, 9 AM, and your next court date's October 19th. Okay? Thank you. Your attorney will be over to talk to you. Patrick Scott. Patrick Scott. We just did Patrick, excuse me, I didn't mark it correctly. Andrea Stinson. Andrea Stinson. Combo versus Andrea Stinson. 23 CR 0054. Are you Andrea Stinson? You born in 1992. The last 4 digits of your social security number 1838.
Yes, sir.
Okay, you're here today for the purpose of arraignment. Do you have public advocacy in district court?
Yes.
Okay, I'll continue that appointment. You have a right to remain silent. The grand jury of Monroe County charged you with escape in the 2nd degree. You understand what that charge means?
Yes, sir.
Counselor, do you acknowledge the identity of your client, receive indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Sign a reciprocal discovery order where your attorney will get the evidence Commonwealth has against you. And we'll have a negotiation day on October 13th at 9 AM. And on October the 19th, you'll next appear in court, okay?
Your Honor, she has another case, 22 CR 89, that there was an agreement last court date for mediation, and I just wanted to follow up if we need to submit a mediation order on that. That's Ms. Hill's case, but I wanted to check that.
I would submit one on this case too, so if we can't
Negotiate both of them
wrap
together?
all up.
Okay, well, we'll still schedule the negotiation and try to do the mediation before then.
Okay, Your Honor. And Your Honor, also on the 22 CR case, you had asked Ms. Hill to bring an ex parte order today, and so I had that.
We'll see that after it's whole. This is from Ms. Stinson.
On the other case, she
Yeah.
told her she was in Cumberland County last month to bring an order, and so she asked me to give this to you today, based on the conversation you had when she was in Cumberland County.
I don't even have another, I've forgotten what we said about that, so I'll take a look at that. Okay, Abigail Vibert. Commonwealth versus Abigail Vibert, 23 CR 0052. Are you Abigail Vibert? You born in 1996? Last four digits, social security number 1327. Okay, we're here today for the purpose of arraignment. Did you have the public defender's office in district court?
This is bringing you downstairs.
Did you say yes, they represented you downstairs in district court?
Here's Mr. Green.
It's the public defender that covers Monroe District.
Your speech pattern makes it hard to pick up on the microphone. Just say yes or no. Did public advocacy represent you in district court?
Yes.
Okay, that's good. Okay, you have a right to remain silent here. I'll reappoint the public defender's office to represent you. The grand jury of Monroe County has returned an indictment charging you with 4 counts of sexual abuse in the first degree and promoting a minor in a sexual performance. A separate indictment and distribution of a matter portraying a sexual performance by a minor. You understand what those charges are?
Yes.
Okay. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order, man, that the Commonwealth is turning over. Now, will there be the need to put this off for a while? Is the evidence complete? Okay, we'll set a negotiation day for October 13th and the next court day, October 19th. Okay, thank you. Tommy Webb. What does it say?
I have a waiver of extradition.
What's he charged with?
Here he is charged as a new possession charge. He has been assessed for drug court and they have accepted him. And that is how Mr. Stockton and I would like to resolve his Monroe County cases, but cannot have him enter drug court as he has a extradition holder out of Tennessee. I have a waiver of extradition that I had him execute as well. But because he has that Tennessee holder, he cannot enter into the drug court program until that's resolved.
Has he entered a plea here?
On the newest charge, no, Your Honor.
Do what?
On the newest charge, no, Your Honor.
It's 23 CR 0047.
Yes. We had
So
discussed,
we're just going to continue that.
yes, Your Honor.
See, this says order to release from custody.
He has a holder from Tennessee.
I
Your
know,
Honor,
but it's 19 CR 0073. Is he on probation here?
Yes,
diversion, Your Honor.
he's under supervision. I should say.
I don't really understand what we're doing here. It says shall commit no undue offense. He's already under that obligation, shall remain drug and alcohol free. He is that. He shall report to the Monroe County Drug Program as soon as he's released from the state of Tennessee.
Well, and
But he hadn't entered a plea on 23 CR
he had
004.
in 19 CR 73, he had a 3-year sentence on possession.
Yeah,
He did pretty well. He had some bad drug tests, and then what got him in trouble was he picked up a new possession case here in Monroe County that he was indicted on.
23 CR 004.
That's correct. And I wasn't gonna make him plead on that if he'd go in and complete drug court. Well, he gets in there, he's assessed, he qualifies, we get ready to place him in drug court, we find out he's got a holder out of Tennessee, they want to extradite him. And so.
What's that charge down there?
I know.
All right.
Yeah.
What I understand, it was possession of methamphetamine.
So
That's what he said.
Yeah.
that's the reason I thought, well, we'll just send him to Tennessee, see what they do with him, and we'll determine whether he can even go in drug court up here again or not. I don't know. Until he's actually confronts his accusers there.
Let's just do a new order continuing his case and do an ROR bond on him and let him execute that waiver of extradition. As soon as he's released down there, he's to report immediately to the Barron County Jail. And then we can take it back up. You understand what I'm saying, sir? In other words, we're gonna let Tennessee have you. When you get things straightened up down there, you immediately come up and turn yourself in up here. If you do that, we'll make sure you get a low bond when you turn yourself in, and then we'll take a look at a referral to drug court before we determine what kind of plea you'll have to enter in 23 CR 0047. Does that make sense?
Yes, Your Honor. I do have that waiver of extradition already executed by
Okay,
Mr. Webb.
Yeah, let me have that come up here. I'm gonna ask him. This is a waiver of extradition that you've signed here. Is that your signature on there?
Yes.
Okay, well, I'll go ahead and have that entered into the record. And we'll set a bond for you, subject to, is Tennessee gonna come pick him up?
They should,
I
if they
confirmed with the
don't,
jail
then-
yesterday that they still have the holder and are going to be picking him up if he is released from
Well, he
Monroe
can
County.
be released to them. He can be released to them, and when he gets finished there, he needs to report back to the Barron County Jail, okay? Thank you very much. No, we had, is there anyone else there waiting to see us? Yep.
Yes, Your Honor.
Out of custody.
Yeah, hold on just a second. Michael Turner, is that right? Michael Turner. You have Michael Turner? Richard Burge was continued till Johnny Bell couldn't be here, is that right?
No, that's one of the agreed orders. Richard Burns and James Bowler are those two agreed orders.
But on the docket, it's got,
DPA, I think now represents.
okay. Are you Michael Turner? Okay, this is 23 CR 0055. Mr. Turner, were you born in 1967?
Yes, yes, sir.
The last 4 digits of social security number 1161.
Yes, sir.
We're here today for the purpose of arraignment. Were you represented in district court by the Office of Public Advocacy?
Yes, Green.
Yeah, Public Defender's Office, yeah. You have a right to remain silent. I'm gonna read this indictment to you. Grand jury Monroe County's returned to indictment for possession of a firearm by a convicted felon. You understand what that charge is, sir, without making any comment about it?
Well, I was told.
Wait now. You understand what that charge is? Yeah. They accuse you of having a firearm as a convicted felon. Do you understand what that is? I don't want you to talk about it because if you talk about it, it can be used against you, okay? Do you understand what that charge is?
Well, I need to talk to the lawyer, really.
But you're gonna get to talk to a lawyer.
But
that's the reason I don't want you to say anything. I'm just asking you if you understand what the charge is, not whether you did it or not. You understand what you're being charged with.
Oh, yeah. Yes, sir.
Okay, there you go. Magic words. Okay. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay, I'm signing a reciprocal order, sir, that the Commonwealth has to give your attorney the evidence they have against you. You're going to have a negotiation date on October 13th, and the next court date will be on October the 19th, okay? And your attorney will be over to talk to you so you can talk to her about this, okay?
When will he be around? I've been trying to keep.
You've just been arraigned right now. Your attorney will come over and explain things to you either tomorrow afternoon or the day after.
This will be Miss Hill's case. She is out of town until next week, so it'll be sometime
This coming week when they come in on Monday, probably Monday or Tuesday, okay?
Okay.
Thank you very much. Now, we previously had Richard Burge's case that was here on an agreed order. Now, will you, on the record, will you tell us what is Mr. Burge there anywhere?
Yes.
Okay, I want him here to participate in this. Commonwealth versus Richard Burge, 21 CR 0088 and 19 CR 0025. Are you Richard Burge? Okay, now what does the Commonwealth have to say in Mr. Burge's case?
Your Honor, he has 19 CR.
Come around here so we can pick you up.
19 CR 25 traffic and a 7-year sentence, 21 CR 88 endangerment, 3-year sentence. He was in possession of marijuana. He was assessed by some other substance, assessed and sent to ARC on August 26, 2023. He left on foot on September the 7th, 2023. So he's there about 11 days. Normally before court, I call Mr. Collins and go over all the revocation cases with him. And when Mr. Collins and I were discussing this case, he said he'd been assessed and he was lined up for a 6-month long-term treatment. I believe.
Yeah, if he could go tomorrow. Your Honor, he has a bed date at the Market Center in Bowling Green tomorrow morning at 8 a.m.
Yeah, and if the court desires, I was prepared to go forward with the motion. I said, Mr. Collins, is that something you want to do? We'll go forward with the long-term treatment. He said, yes. And I said, okay. So I discussed the case.
What was the second charge he had?
Wanton endangerment first, 3 years.
What
Is a DUI case, is a case for him. And I can't remember the lady's name. We've had her before. We're together and there was that one single car running off the road, I think. Donna Rich, and evidently Mr. Burge pled to the wanton endangerment and the DUI on that, and he was sanctioned but wasn't revoked on the 7-year sentence, I believe.
Well, I want an order drawn up that I'll sign that will hold in abeyance whether we're going to revoke his probation or not. And we won't revoke it if he successfully completes his 6-month program down there. And if he does leave the program, he shall immediately report to the Barron County Jail. If he doesn't do that, he'll be guilty of escape. Okay. Okay. Thank you, Mr. Burge. The other one was it James Bowe?
Your Honor, Mr. Bowe left for court this morning in Barron County Family Court, and they've not gotten back with him.
Okay, what were y'all going to do with Mr. Bowe?
He had 2 or 3 positive tests for methamphetamine, and we were going to have him assessed for drug court because he has a job. And
okay, I will go ahead. When Mr. Bowe comes back, tell him his case was called, his attorney was present, and there was an agreement between the Commonwealth and the his attorney to have him assessed for drug court here in Monroe County, and he'll be hearing from us about that, okay? Okay, thank you very much.
Check. One more thing, Maria Rivera was on the docket for a bond revocation, but it's Bruce Brown is her attorney, and they did an agreed order continuing this because he couldn't be here today. But bond holders are here when to come off.
Is Maria Rivera there?
Yes.
Okay, your attorney is sick, Miss Rivera. Evidently, he's got a problem, but the people that were on your bond are here and want to come off the bond. Were those the same two people that were on?
Yeah,
the
one
other
was
bond?
on Mr. Padilla and the other one was on Miss
And they
Rivera.
want to come off your bond. So I'm going, since you're incarcerated, I am going to release them from the bond. When's Miss Rivera scheduled to be back? Now? October the 19th is your next court day, okay? Thank you very much. And is there anyone else there in Barron County that was supposed to see us?
We had some that was on our docket, but they're.
We don't have anybody else on the docket.
No.
Okay, thank you very much. Okay, you know, cut them off. Does that complete the criminal docket?
Thank you.
Thank y'all very much. Let's go off the record then.
That means he's not going to see y'all.
So we have a child support docket. I want to complain before we start about the barbecue being closed on Thursdays.
I know,
It's gonna be harder on you.
got to get on it.
Okay. Yeah, Fox versus Fox.
Continued October the 19th, please.
Gallup versus Gallup.
October the 19th for review, please.
Hagan versus Hagan.
Judge, could you swear in the statement, please?
Swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yes,
State your name for the record, please.
Taylor
You
Staples.
are currently employed by the Monroe County Child Support Case. You're familiar with Monroe Circuit Court, Civil Action number 22 CI 40.
Yes,
Dustin Hagan is before the court and given notice of this hearing.
yes,
He is ordered to pay $650 per month. Is that correct?
yes,
He has an arrearage of $1,950. Is that correct?
yes,
And as far as you're aware, he's an able-bodied person capable of providing support as previously ordered. He's neither incarcerated, but he is a member of the armed forces, but he has been communicating with us about this.
yes.
Judge, we'd ask you to adjudicate his arrearage or to pay it back at $200 per month.
Okay, that's very simple. Hagan versus Hagan. No, that's right. This is Hessen, excuse me.
October
Hessen.
the 19th for review, please.
Hudson versus Hudson.
Continued October 19th, please. CI 114, continued October.
Liz. That is 10 CI 00114. Keith versus Keith.
Continued October 19th for review, please.
Roten. Roten.
Roten. Judge, this case was previously closed and Ms. Dooley has requested it be reopened. We're asking,
You want to come around? Wait a second, it gets up here. This is Latasha Ray Roten versus Robert Chandler Roten. Are you Robert Chandler Roten?
Yes, sir.
Okay, go ahead.
Judge, the plaintiff has requested this case be reopened. In order for the cabinet to be involved, we have to be made the payee. So we're just asking that you make the child support, Monroe County Child Support Office on behalf of cabinet the payee, so that then we can pursue.
No, is there an arrearage?
She closed it.
She had stopped support at one time and now she's requesting it to be reinstated.
You understand that?
Yes, sir.
Okay. Okay, how much is it
We haven't done this. We have to do this step now.
before you can calculate it?
Administrative
She
regulations.
may make an appointment with you to come in.
Will just bring us the income information and we'll tell him what it is.
Okay, well, just step away and tell him what he needs to bring to you, okay? Thank you, sir. Thurman versus Thurman. Assume that's the last case, was it? Okay, we go to Hollingsworth versus Asher.
Good afternoon, Your Honor.
Good afternoon.
Your Honor. Chris Davenport on behalf of the plaintiff. We have a couple motions before Your Honor. After the filing of those, Mr. English filed a couple motions of his own.
Mr. English.
Imagine that. But I'm happy to address ours if the court, if that pleases the court.
Go ahead.
Judge, this action is a will contest. We've been in front of you a couple times. There's also another element to the case, and that is a claim of misappropriation during the decedent's lifetime by use of a power of attorney. So there's two elements here that come into play. We have propounded written discovery on Miss Asher, the defendant. She's the executrix and also was the attorney in fact. She's objected to a few things that I think are, frankly, I think they're relevant, although that's not the applicable standard for production at this stage. One is we asked for bank statements of the decedent. We actually didn't get a clean response to that. We got an objection, and then we got some items. And we know, we have reason to believe there is at least one more account that the statements of which have not been produced. I'm asking that I get a clean response to that. And if Miss Asher says this is the only one there was without an objection, then I can go from there. But with the objection interposed, I don't think that's really proper. There's no basis to object. Secondly, we
Let's
asked.
do one at a time, okay?
Yes,
Is the
sir.
second one related to that, or is
No,
this
sir.
a bit of it? What's your response to that?
My response is that as executor, we have the obligation to go out and search and try to find whatever records we can. We don't know conclusively what bank what bank accounts the decedent had. We have produced those accounts.
Wait, executor, are these bank accounts closed?
Yeah, they were bank accounts of the decedent. Excuse me, I may have misspoken. They
Yeah.
were bank accounts of the decedent. We have tried to get those records that would be
So
responsive.
they were zero balanced at the time the estate was established, or what?
Yes, yeah. And we have produced those records. Now, if they want to go back and look and get other records from other sources, i.e. if they want to get them directly from the bank, they can subpoena those and obtain those. We don't have them. We have provided everything that we have and everything that we
So
have.
you say that the accounts were zeroed out and there were no assets to come under the control of the executor? Well, I don't know that we knew about is wide open. If you know about them, you're responsible for marshaling them, aren't you?
Absolutely.
Okay. Do you believe that there are accounts that had previously been zeroed out or closed that didn't have assets? Where are you getting this information about these additional accounts?
Just from our review of his records, there's indication of other accounts and
You know
frankly.
where the accounts are?
Correct, at least one of them.
Okay.
And I don't have that in front of me, but so the court understands, if the response was, these are what we're aware of, and she signed those, I wouldn't be arguing this, but they interposed an objection. They objected to the question, which arguably at a later point allows them to say, I don't know what it allows them to say, but there's no basis to object.
So let's get a clean answer to this. Okay, you're telling that you provided them all the accounts that you're aware of.
Yes, sir.
Okay, well, that takes care of that.
And if there are other counts that they have knowledge of.
But you're not charged with that. You're just charged with what you're aware of. And you've made that statement, so that completes that issue. Okay, now what's the next issue?
Second is we asked for Miss Asher's returns. We asked for 5 years. And the response was an objection and nothing was produced. I will remind the court that one of the claims here is misappropriation during the decedent's life.
What did you want? The income tax returns?
Miss Asher. And we're happy to have that under protective order. And, you know, it's necessary for us to review her financial situation.
You have any objections to that?
Yes, sir, I do. It has absolutely no relevancy, nor will it lead to the discovery of any relevancy over what what is at issue in this case. Whether what Ms. Asher's income tax returns are not relevant, nor will they lead to the discovery of relevant information. They have no basis to request that. The issue in this case.
Well, let me ask you something here. Have you reviewed her income tax records?
No, sir.
Okay, well, then you can, you know, as far as the relevance or not, it would appear to me, rather than having to provide them, that a sit down together with counsel just to look if there were any unusual or large amounts that could not be explained as to where she got them. I can see how that could be relevant if there were large amounts of money there. And that could just allay any problems that they have. It could very well be that there is no relevance, but how much money are you talking about? You think it was absconded?
Misappropriated?
Yeah.
Well, we're not entirely sure yet because one of the next requests we're going to have is going to get into that. But I appreciate your honor's perspective that if there's large income reflected on the tax return or large transactions or something along those lines, I'll tell you, I'm also interested in the converse, probably more so. If the tax returns show very little, if any income, then the question is asked of the attorney in fact, how did you afford the lifestyle that I'm aware she was affording at the time? So that sometimes a negative.
And she's frugal.
Possibly.
And again, that's the kind of fishing expedition that the civil rules put limits on. They have to show what specific transaction they claim that my client used a power of attorney for that was not for the benefit of the decedent. And until they come up with one shred of evidence that she misused the power of attorney, there is absolutely no basis for that claim to go forward.
What is your basis for believing that there was?
Last time we were in front of your honor, Mr. Wilson here was present for our firm. One thing that came up is at least 4 checks that were endorsed by Miss Asher, multiple thousands of dollars that were endorsed by her. My next item is I want an accounting of what she did with money she received, also objected to. So
who were the checks made out to?
They were made out to Mr. Hollingsworth. I think some of them were the sale of cattle, as I recall. She endorsed those. We, from the bank statements we have seen, there's no explanation for how that money was disposed of. And so one thing we asked her is to provide accounting for that. Objective. Nothing. So that's why I say some of these issues go hand in hand. If we can't find where the money.
Let me ask you these. I think, you know, what Mr. English says about particular acts has some, you know, has some gravitas here. Like, I mean, if you've got particular transactions that you believe she endorsed and want to follow what happened with the funds to them, then I think you need to ask about particular documents.
All I want.
Yeah. And so I think that will do it. Now, if we get into a number of those and there's a pattern that's created, then I'll come back and reconsider the second one, but I'm going to hold that in abeyance till we get some more indication that there has been a misappropriation of money. I mean, if you start getting into that, we'll take a look to see if we can't trail the money. You know,
Yes.
we'll follow the money. So that's number 3 was asking for what?
For an accounting of the money that came into her hands, and as the attorney in fact, and I can point.
But do you know any money that came into her hands?
The 4 checks. The 4
Well,
checks.
then
that were
you
endorsed.
need to identify those
Yes.
that she endorsed them, and she needs to preside some accounting. And I'm sure anyone that is a responsible attorney in fact that endorses a check as attorney in fact will keep some record as to what they did with the money.
Yes, sir.
because you're opening yourself up to this sort of thing.
Absolutely. So
Yeah,
I think
so-
I think they actually have that information because I believe it is deposited in Mr. Hollingsworth's account.
Yeah, well,
We would have a different, we will argue that at a later date.
okay, argue that, but so if you'll give them particular situations where you believe that his estate funds came into her, under her control.
And at this
what she
point-
did. Okay, and
I'm
what's your
sorry.
fourth? You got a fourth thing?
Before I do that, you're holding in abeyance the tax return issue. at this
I
point,
am
is that
right
correct?
now.
Okay.
You know,
The fourth thing was for her to produce vehicle titles that belonged of cars that belong to Mr. Hollingsworth.
were some transferred out?
Well, we know that her ex-husband caught a speeding ticket or caught a ticket in one of those vehicles after Mr. Hollingsworth's death. So we're interested in making sure we know what all the vehicles were at the time of his passing. Without, I mean, I
Is
just.
that a
wanna-
matter of public record?
Yeah.
Is that a matter of public?
Well,
I'm just
are-
asking.
Arguably, I mean, but at the same time, as the executrix, she should have that information readily available to her, I would think.
Well, is it listed on the inventory? Have you got an inventory that's a state file?
I think the inventory showed 2 vehicles on it.
Okay, and then did public records show any more than that?
I can't.
Okay, well, I would suggest before I make any ruling on that, you see what the public records are, any transfers in and out of vehicles in his name for a certain year before that. And then after his death, it would have had to been done. The attorney, in fact, was not able to, the power of attorney expired at his death.
Yes, sir.
So there couldn't have been any after that. So if there's a discrepancy in what was in his for a few years before that, and I would think that you'd be entitled to see those titles to see how they were transferred, and who got them and what they were paid for and what happened to any proceeds that were derived. But other than that, it's not. What's your next one?
Next is, Your Honor, is I asked for an accounting or a listing of assets that she will ultimately claim were gifted to her by Mr. Hollingsworth. And frankly, you know, I am not inclined, Your Honor. I would not think it would be wise necessarily for me to ask her about things I may or may not be aware of, and for her to state whether they were gifted to her. Some of this, I don't want to necessarily show Miss Asher some of the cards I'm holding and some of the information I have until she tells me what the nature of these transactions were with the decedent and her ward at the time. I would think she can tell me what, if anything, was gifted to her. And then I think I deserve an answer on that. I
Well,
think
were
it's-
the gifts made via documents, or what kind of gifts are you talking about?
We don't think there's going to be any documentation to support a claim of a gift. I'll say that.
Yeah. Well, are we talking, what amounts of money are we talking about?
Potentially, I think, very significant sum.
Well, if they were of a certain level, they'd have to be reported. She had no family relationship. Is that correct?
Also a reason I wanted the tax returns.
Yeah. Yeah.
There was no familiar relationship. I can tell you that.
What do you have to say about gifts?
Well,
We all like gifts.
we all like gifts, Judge, and it's, number one, the civil rules don't say we get to play hide the ball. We get to play what we think is something that we may be able to impeach somebody with, and then come try to spring on them and try to come up with some kind, make some issue out of some specific question. What it says is that we're all supposed to respond to interrogatories and requests, lay our cards on the table, and tell everybody what it is that we are contending in the complaint. We have been asking for this information as well as trying to get the person who is the only person who has the ability to bring this lawsuit to appear for a deposition, and they won't show up. If they've got a claim that there was something that was an inappropriate gift, we have asked them to state what it is, give us the documentation, and let us know what it is they're talking about. We've received no checks. We have received no indication or anything else about what it is they continue.
I don't think
once
it's an
again.
inappropriate inquiry to ask if you received any gifts.
Sure it is, but if
You
we
think
had
that's
asked-
inappropriate for them to ask if she received any gifts from the decedent? If so, list the gifts. Is that inappropriate?
No.
Okay, then we don't have a problem on number 5 then.
All right.
Okay. And at some juncture, you know, I can see how they would believe that they might not be aware of all the gifts. If there were any inappropriate gifts, some people usually don't publish them around and tell everybody that they got inappropriate gifts. Okay, what's number 6?
That's all of that motion, Your Honor.
Okay.
The second motion we filed, the second in time, requested 3 things that the executors do. The first was to park the decedent's vehicle and to hand those keys over to her counsel. Like I said, her ex-husband, I believe it was a Camaro or Corvette one, was pulled over, got a ticket, was driving it with unregistered tags. We just don't think that the vehicle should be used for anyone's.
Well, that's
benefit.
true. It
I
should.
disagree with you.
Okay,
In
that's,
all respect, Judge, this is.
they have a
situ-
claim to the car?
No, sir, they don't. They
Okay.
don't have a claim to the car. They don't have a claim to any of the assets of the estate
Okay.
until they have established that there was a problem with the will.
I'm
and
talking
whether
about your client. Was the car left to your client?
Yes.
Oh,
She's 100% residuary beneficiary.
of the car
Of
too. Well, yeah, I
all
thought the car was separate.
It's the will that was probated, that is at issue. She's the 100% residual beneficiary of the will.
Well, I think there is, I don't know. This could go on for a long time. Could be litigated for a long time. It could be in the Court of Appeals for a long time. I'm very subject to messing something like this up and be reviewed for a long time. Y'all are real smart lawyers. And I'm sure you'll find out all sorts of things that I do wrong in the case before it's over. It could be, I don't, if this vehicle was left as in the residuary clause, I would suggest that there be a record kept of how many miles is on it and what kind of condition it's in now. And if they end up losing it, then you could, when you started to look at damages anyone did to it, the difference between the value when they got it wrongfully and what it is when you get it back. Is there a limit on them disposing of any of the assets of the estate at this juncture?
No, sir. Although we have agreed.
No,
Agreed, yeah.
that was
I
at the
thought-
very first hearing.
So the corollary to that would be that, you know, that they should not dispose it and they shouldn't do anything to diminish the value of it. Now, the occasional use of something like that, and the number of miles on it, you know, I'm sure Mr. English then would be glad to tell you how many miles a Corvette has on it now or something like that. And then you could, if it gets down to the point where we're arguing over the value of the Corvette, then I'll make a judgment. We get an expert witness here on what Corvettes are worth with so many miles. What's your next thing?
The next thing, Your Honor, is they are receiving, the estate has received the funeral expenses. They are incurring interest and penalties. That fee, that bill keeps going up. It's not been satisfied. I believe there's sufficient inventory in the estate to satisfy. We've
Why the
asked that
funeral
repeatedly.
bill hadn't been paid?
We haven't, no one had used.
Yeah.
We are waiting to the appropriate time. Do we have the sufficient cash to pay it?
I'd say it's appropriate.
Well, we've got to have some cash to pay.
Well, I
it.
mean, if you've got anything, why don't you suggest what needs to be disposed of to pay the funeral expense? And y'all may do that by agreed order. There might be things that are more easy to liquidate than others and to pay the funeral expense, okay? If you can't agree on that, then we'll start counting spoons and things which ought to be sold to pay the funeral expenses. How much are the funeral
I think
expenses?
they're about $12,000.
Cheaper get cremated.
17 now.
Yeah.
17.
Yeah, cheaper get cremated. Okay.
Last issue that we have, Your Honor, is kind of along the same lines of just trying to protect the estate. There were numerous parcels of real property that belonged to the decedent. The estate has suffered numerous break-ins since its passing about a year ago. We have asked the executrix a handful of times, numerous times, to please insure the property. Initially, we were told we can't insure it because it's vacant. We've gone out and found the State Farm and 2 other insurers will insure this property. And we've asked, please insure the property.
What's being stolen?
I can't tell. I know that.
Y'all aware of any, not that anyone would break into anybody's property after they pass away, but what's been stolen,
A whole lot of things, Judge. Right now, there's a missing tractor that was there when we first went down to look at the property.
Well, the problem that I have with these things, and I've lost a lot of these cases. Your co-counsel beat me in 2 or 3 of them on the state cases. Your partners, y'all might have beat me one. I don't know. I lost a lot of these kind of cases, but things seem to disappear, and the people that have control of them on occasion make them disappear and have no reason, to protect them if they can sell them somewhere else. And I'm not accusing anybody of doing that, but it raises suspicion on the people that don't have control of the property. How expensive is this insurance that you're talking about?
I don't know off the top of my head. We've provided that information. When we went out and shopped it ourselves. So,
well, what do you think about protecting the?
Your Honor, we went out and tried to purchase insurance, and we have been told that because of the condition of the physical buildings and so forth, that they are not insurable because they are vacant, which brings me to my motion as to what we think.
Good segue, huh?
Well, if I could have last word on that, if they were told by someone a reason other than vacancy, I'd like to know it, because we didn't shop this until we were told we can't insure it because it's vacant. We went out and provided 3 insurers that said they could do it.
It probably costs more if it's vacant.
Probably, but I haven't heard anything in response to that.
I find very few things that aren't insurable if you pay enough, unfortunately.
Well, and that's another thing, is that we believe that the most efficient way to handle this is let's sell it. Let's have an auction. Let's have everybody that comes in and thinks they may want to buy this bid on it. Therefore, we liquidate the assets, which is specifically what the testator requested. We then hold we can then pay those expenses, such as the funeral bill and other expenses.
How do y'all feel about that?
So I filed a written response yesterday. That was Buzz's first motion that he filed last week. That was just to have a sale. My response is this. My client, and Mr. Goatee is a cousin of the decedent. He is the attorney, in fact, of Cliff Hollingsworth, who is the surviving nephew of the decedent. That's who the plaintiffs are in this case.
Yeah.
Their desire will be to keep some of the real estate in the family. Some of these parcels were held in the family for a long time. Some of the assets.
How much?
Probably 150 acres.
Well, no, but here's the thing about it is this gentleman here is the attorney, in fact, for the nephew.
Correct.
How old is the nephew?
Right at 40, 39. Big 40.
Why isn't he doing this? Why you have an attorney? In fact, is he disabled or what's the deal?
He doesn't have a guardian. He does suffer from disabilities that make it difficult for mental disabilities for him to conduct his own business, but he does not have a guardian.
Well, I mean, so does he have any heirs? Does he have children? This nephew? Well, I don't understand why it's going to be kept in the family very much. I don't understand that. I could understand it if you had a legacy of people that live there and all that sort of stuff.
I'm sorry, his half brother, he's got a son.
Be that as it may, my response I sent to Buzz yesterday is, we're not necessarily opposed to selling some things, but I would like to know without I object to an order that says Miss Asher could sell whatever she wants.
I'm not saying that she can sell it.
Yes, sir.
Okay, I'm saying it'd be sold. And maybe y'all could reach an agreement on how the sale is going to be conducted, and if it's real estate, if it's personal property, and who could sell it, and that sort of thing. If that can be agreed upon, I mean, and you get the right person selling it to bring the most dollar, and then you don't have to worry about this stuff being stolen anymore.
I think that's a great idea. In fact, that's exactly what we proposed.
No, that's
And
what
and
I.
we said, and we said.
Well,
let's
there's a
sell it.
difference in them saying that you should be able to sell it, and then it collectively be decided upon who could sell it and then monitor it. And maybe you suggested that.
Basically suggested
Okay, well,
that
now
we
we're-
have a public auction, that we advertise it.
Well, let's see if we can go a little farther than that. Let's see if we can reach an accord on who sells it, what the terms are, and when it should be sold.
Sure.
Okay, and if y'all will sit down and talk about that to the benefit and nobody put any unreasonable requests on it, then we can liquefy this stuff and, you know,
We have it
and then we have,
and
and then we
it's-
just be fighting over what everybody fights over anyway,
Yes, sir.
money. Okay, now that finishes you kinda, and that was the first part of your motion, right?
Yes, sir. it
What
was.
else do you have left?
I have a motion to compel Cliff Allen Hollingsworth to appear at a deposition. We had it.
Is that the nephew?
Yes,
It
Okay.
is.
And you say that he's impaired?
he is, but I mean, the request is well received on my part. I'll be frank. We had a deposition date set. Mr. Hollingsworth, Cliff did not appear. Well, all I'm going to ask in response to this is you give us 45 days to conduct that. That we do it here in Cumberland County. I will
This is
like.
Monroe
this is
County.
I'm sorry, Monroe County. Anytime I get on 90, I get a little lost, Your Honor, you know, when I hit this way.
I found people in Bowling Green feel that way about it, except when you come over here to collect these large attorney's fees, and then you find yourself over here all the time.
Well, I hope
But
I
here's
get,
it. Yeah, Nixon says you can stop out there at the drugstore. He texted me a few minutes ago if you need to be refreshed on the way back out.
he educates me all the time.
Yeah, let me ask you about something here. What's the problem with the deposition within, let's say, 2 weeks?
Well, the biggest thing in 2 weeks will be my schedule, frankly. But what I will likely have to do.
You ought to become a senior partner in a larger firm, and your schedule would be more open, you know.
I hope I get to be a.
3 weeks, 3 weeks.
Um,
I'll do it at his office.
It's gonna be easier to do it here. The point I'm making, I'm gonna need to probably pick Mr. Hollingsworth up. He does not have a driver's license.
Where does he live?
He lives,
Mud Lick. That's where the wrestler was from. What it, Farmer, whatever. Hillbilly Jim, yeah.
How about this? Is Wes still here? Wes will probably let us, Stevens will let us use the conference room. Would you all be? Oh, there he is. Could we borrow a conference room?
Percentage of this.
I knew that was gonna come, you know. We've got a lot of facility. We got a lot of rooms here.
Sure.
You know, there.
Yeah, sure.
Yeah, and as far as that concerned, you can use the judicial chamber in here. There's a tremendous conference room in there that's very seldom used. So let's just do it here at a neutral side.
That's fine. We'll.
Okay, what, you got your calendars with you? Let's just
Yes,
pick
sir.
a day
I
certain.
keep that everywhere, almost.
Yeah. Yeah.
Buzz, you want to go first?
Well, I had suggested
You'd suggested the 6th.
6th. Is that not going to work?
That won't work.
How about the 9th?
That won't work, but the 10th would, or the 12th.
Let's
If it's in the afternoon, I'm okay with.
let's
Yeah.
let's do it the afternoon of the.
It needs to be the 12th. Can you do it the 12th?
Jimmy reached out to me yesterday.
That's fine.
Actually, I have to be in front of this court over in Clinton County on October 12th.
So Thursday,
Yes, sir.
hold on a
I
second.
could do it in the morning.
I mean, I can do the 12th, the morning of the 12th, anytime the 12th.
Okay. On the 12th.
The morning of the 12th. And that would be good because I'll be available that morning in case you have any glitches that you want to call in, you know, about anything that goes wrong on the thing. Okay, you got that scheduled. Now, what's your next thing, Mr.?
Well, I have a motion to compel the plaintiff to answer interrogatories and provide documents that have not been provided.
If I might, before we get into that, Your Honor, I got that Monday afternoon. I filed an objection this yesterday. I have not had time to go through. It's a very long motion. You know, I think that your local rules require 5 days notice. That was not complied with. And I think it'd be a much better use of everyone's time if that got.
How many things are asked for there?
Well, we want the damages.
No, I didn't ask you what you want. I asked how many of them are.
There are about 8 or 9 of them.
Well, I tell you what, let's do. Let's just flip down through them to eliminate anything that will not be problematic. Anything's problematic,
Okay.
we'll give you some additional time, and I'll sustain your motion about timely filing. Okay, just flip down through them real quickly.
Want the damages. He has a cell phone.
I do not.
Well, wait, you don't need to say anything.
that-
I don't want a speech here. I want something to go down through a list.
I want a list of damages and the documents that they're requiring.
No, that'll take some time. Okay, go to the next one.
I want communications that he claims, particularly, I think there were text messages between Tina Asher and Guy Mitchell Hollingsworth, text messages.
Okay, go to the next one. That'll take a little time. Go ahead to the next one.
I want interrogatories of when they claim that that Tina Asher has breached fiduciary duty using her power of attorneys to misappropriate money for her own benefits. I want to know what the factual basis is for
Once they
that.
finish their discovery, I'm sure they'll give you a more succinct one. Go ahead.
I want.
Now, let me ask you, your knowledge of the civil rules is much more extensive than mine. But aren't they able to get full compliance with their discovery interrogatories before they're compelled to answer yours? I believe that's the way it works.
Yeah.
So we ain't got to you yet, but when we get to there, I'll be very liberal in granting these things. And go to your next.
Understand. We want we want documents to support their allegation that Guy Mitchell Hollingsworth was susceptible to undue influence.
Okay, go
We
ahead.
want
Go to the next one.
documents that they claim are a basis that Mr. Hollingsworth lacked testamentary capacity. We want.
Well, let me suggest something. Since y'all are going to be over there on the 10th, did you
Yes, sir.
say?
Well, it's the 12th.
12th, on the 12th. Why don't you just give opposing counsel an opportunity to file specific objections to your motion, and y'all come over on the 12th?
Be happy to.
And you can do the deposition over there if you'd like, since you'll all be there, and then we'll hear your motion and rule on what they have to comply before there's total compliance of your thing. I think that'd be more fair to
That's
everybody.
fine. I will
Okay,
do it in Clinton County.
that'd be fine. We got room there in Clinton County. We can give you one of those cells back there where the criminals. Okay, and what else do you have besides that? Okay, now,
So we're going to do a deposition in Clinton County.
I think it'd be better to do the deposition. That way you can have your motion. You can have your response to the motion since it hadn't been filed. And I think a bunch of these things, the response will be, oh, I will provide you that as soon as we finish our discovery. I'm sure that
It was
that's,
actually, a lot of those did have substantive responses to them. They just didn't think it went far enough.
okay.
So we cited the medical records and things.
But
like that.
substance is.
Well, we rely upon medical records. Well, medical records. I mean,
Do you have medical records?
Oh, yeah.
Well, if you have medical records, you need to show them what
They have those. They were.
The specific medical record is that he is relying.
Well, you're talking about the parts of the medical record.
Yes, sir.
Yeah.
And so the court understands they were received by a subpoena. They've got all the records they have. We didn't go out and get records.
Well, at some juncture, I think they're entitled for you to point out what
Yes.
particular portions, and they feel like they're at that time. Now that these are the medical records of voluminous, but this medication was given on this date, this indication of dementia was given here, that sort of thing. I think you need to get your experts and whoever ready to give them that information, because that could, if you ever get to the point where you have enough information to negotiate it, that would be crucial for them to make a decision on where they feel like that the capacity could be in danger of a verdict, okay? So we'll address all those, but between then, try to be generous in providing us as much specificity so we can take that stuff off the table.
Yes, sir.
Okay. Now I'll remind you that once y'all get ready, we can pull the trigger on the trial here pretty quick. It doesn't take long. You know, we're talking about 90 days out or something like that.
You could probably see most of what I'm trying to follow up on is on the misappropriation side.
Yeah.
I frankly pretty much ready on the other side or very close to it. So it's a discussion Buzz and I will have, but I guess we'll maybe see you in Clinton County. Maybe that won't be necessary. It will be over.
Well, I'll be ready. You just call the clerk's office over there, or maybe call you. Just tell us if they're coming or not. Just copy us with the motions.
They need to arrange, I don't know where.
I'm gonna let Buzz arrange for the room to depose Mr. Hall.
We'll find.
But you can go with David Cross's office and see some political paraphernalia hanging all over the walls or
Go to
something.
Mr. Cross, or we've got other places.
Yeah, yeah. David Choate's got an office back there. If you're having trouble finding someplace, you know.
We'll find some.
Okay, is there anything else?
No,
Well, thank y'all very much.
Thank you, Judge.
Yeah. You gonna draw an order, Mr. Chairman,
I will.
and circulate to him?
Yes.
Okay, thank you. Bigger staff versus bigger staff. Hello. Are you Miss Biggerstaff?
Yes.
And you Mr. Biggerstaff? Who filled this out for you?
I did.
Now, do you work anywhere, sir?
Yes, sir. Grandview Welding,
Where?
Grandview Welding,
Yeah, and how long have y'all been married?
20-some years.
just 21 years.
And where do you work, man?
I do not work.
Have you ever worked in the public anywhere?
Yes.
Where did you work?
Kentucky Apparel and Carhartt.
Yeah, well, those kind of jobs are pretty much gone, aren't they?
Yeah.
Yeah. Okay, well, I'll review this and all probability I'll sign it. I haven't had access to the forms yet. I'll just go ahead and sign it. How much you make a year?
Like $2,400 a month.
And what, are you drawing something right now?
Not yet.
How are you living?
I'm staying with our oldest daughter and her son.
Yeah.
I mean, her husband.
Okay. How much is the filing fee? Now, you want the divorce too?
Yes.
Okay, well, why don't you pay the filing fee?
Fine with me.
Okay, is that all right with you?
Yeah.
Yeah, I'm gonna reduce the filing fee by 50% for you, because I mean, you're not making a fortune, but you're making more than a lot of people are, and she's indigent on the thing. So I'll just- How much you say it was?
215.
Okay. I already paid 115, okay. And it's ready, once you pay that, I guess you already get it signed, so you can submit. Isn't that right? Did you look at it? So if you go down and pay that, I might even sign it today before I leave. That sound like that's quick justice, isn't it?
Yeah.
Okay, thank y'all very much.
Thank you.
Yeah, Agrich versus Kruger.
My motion, Your Honor. Mr. Kruger has passed away. This is just our motion to substitute, bring his estate in.
I'll have to print it out. You have any objection to substitution of party?
They don't have any objections.
Okay.
I have issue with picking the clerk. She needs to put us before the property. English. on the call
You
sheet.
might learn something with these big city lawyers come
I
over
want to
here.
see my grandson as soon as I get
Oh, you just ought to quit taking these cases then.
out.
Man,
That would be one option.
your man of your means doesn't really need to work out here, grovel with the rest of us, so. Okay,
Well on this.
okay, if you'll give me, you got an order?
There was supposed to be.
Didn't start out that way, it just ended up, that's right. They asked me to do if I did pro se work, and I said not intentionally, but I ended up doing a lot of it.
She was married to my first cousin. Started 8 years ago.
Okay, there it is.
Thank you, Your Honor.
Okay, thank y'all very much. Gym Finance versus Nancy Senderovsky. What you got here? Hello.
For default judgment, represent the plaintiff.
Let me have the file here. Only thing you check service for sure, right?
Yes, Your Honor. She was personally served by the Sheriff's Department on April the 6th of 2022. We never received any answer or any type of pleading, and she
Trying to see the service. And these are electronically filed. Look at this. Just check the service on that for me just real quickly. Oh, it's right there. Aha. I looked at the back one. Okay. There were just these blank ones in the back.
That's all I had too, Your Honor. Just I think I got that date off the court net.
Yeah, it's in here if you want a copy of it. Okay.
Thank you very much. Have a good day.
Mid-South Capital Partners versus unknown heirs of Danny R. Will. What is that? Nobody appearing on that? That's the one somebody wanted to appear by remote on.
Send the link to my office.
Wes Stevens was involved in this. Is he gone?
Lindsay Stafford with Hunter Jones office.
U.S. National Bank versus John Sawyer Beach.
Good afternoon, Your Honor. Maria Stewart on behalf of plaintiff today. Your Honor, this is plaintiff's motion for leave to file an amended complaint, Your Honor.
On behalf of the Beaches or Walker, Your Honor, we have no objection to this. This is just housekeeping that needs to be done.
Okay, you have an order?
Yes, Your Honor. Thank you.
You just want a distribution or do you want a copy to take with you?
Distribution is fine, Your
Okay,
Honor.
that'd be
Thank you.
great. Thank you for your patience.
Thank you, Your Honor.
Dot Capital Investment versus Bobby Wood.
Hello, Your Honor. This is Justin Ramey. I
Yes,
represent the plaintiff DOT Capital Investments, and it's a motion to resell the property, reschedule sale of the property, I should say.
the Master Commissioner is here. Has it previously been scheduled? What happened to the sale? Come on up here where they can pick you up.
A little over a year ago, maybe, but it was scheduled, advertised, but we canceled it completely. They paid the fees. And so we still have the file. Now, it is my understanding from my last audit that the $200 judicial sale fee that's paid to the AOC has to be paid once again before they may obtain. the
Once it
order
gets
set.
canceled, right?
Yeah, once it's been about 6 months, they have to pay that again.
So you have no, you would agree that for it to be rescheduled, obviously, and they just need to forward the fee. It's 200 and what now? 13th of this month. So another one has been paid. Correct, counsel? You pay you.
That's correct. Yes,
Okay.
and the
Okay,
AOC order was tendered as well, Your Honor.
Okay, well, I'll be glad to sign the order then to reschedule. Okay, thank you very much.
Thank you, Your Honor. Have a good day.
Okay. Make sure I sign that. Now we'll go back to this one case. Your list is counsel. It's Mid-South Capital Partners versus unknown heirs of Bobby Will. You're listed as attorney for the plaintiff, Mr. Stevens.
Mid-South Capital representing
Mid-South Capital Partners, LP.
So John, and just as attorney for the defendant is the county.
It didn't say that for me yet. So,
Hunter Jones is listed as the attorney for the plaintiff.
yeah, well,
It was his associate Lindsay Stafford that requested it.
That's not my case, Your Honor, if you're thinking it's mine.
no, I'm not. You're finished, aren't you?
Yes, Your Honor.
Okay, you can be excused.
Thank you, Your Honor.
Yeah. What kind of case is this?
I'm sure they just sued the county
For
back on
taxes.
taxes is my only involvement.
This might be a tax lien case, mightn't it?
Yes.
Well. Ms. Brown leaves, she leaves. Yes. This is a motion for judgment order of sale too. I don't know if she's familiar with this case. Let me have this file here. This is Mid-South Capital here.
Judge Ms. Brown has entered the courtroom.
Are you familiar with this Mid-South Capital Partners versus Williams, Norton's, McShane Carver, and other people? Are you interested?
Your Honor, I believe we have had a file on that before, but I'm not immediately familiar with it. Has he filed a motion for judgment?
Yeah, and for sale.
Is that an old one?
Evidently, it's one of these certificate of delinquency.
It's a 2020.
Yeah. And he called in and asked if they could be heard online. And
That's Hunter Jones.
did you call in?
Yes.
Yeah.
But
Lindsay
it's
Stafford, I
her
think.
associate, his associate.
And they have paid, it's like the $200.
Just.
Well, I don't know whether to sign it or, I mean, they said they were going to be present. I don't see anything. It's a default. You want to take a look at it here and we'll go off the record. You take a look at it and see if there's any reason why I shouldn't sign it. Okay, let's go off the record.
I talked to Jimmy Long this morning yesterday about something. He said, I hadn't done my taxes for last year.
Do you have anything else? What do you have?
Your Honor, I have Reliant Loan
Go back
Services
on-
versus Ruby Norris,
Go back
22
on the record
CIs.
just a second here. I didn't see that on the docket. Did I skip over it?
So we have page 5.
Yeah, there it is. Excuse me. Reliant Loan Service LLC versus Ruby A. Nars Perkins.
Your Honor, this is a motion to substitute plaintiff. This one as well is just really doing some housekeeping, Your Honor.
Okay, we'll get that.
There's no objection. As a matter of fact, defendant Citizens Bank filed a reply stating specifically that they have no objection.
Okay, if you just you gotta take the order out of there. Did you send an order here?
I believe so, Your Honor,
Won't you look at that
but I
file?
have a hard copy,
Okay.
quite handy.
Okay,
Thank you, sir.
thank you.
Your Honor, that concludes my business.
Have
report.
a
May be
safe trip.
excused.
Have a
Thank you,
safe
sir.
trip, yeah. We have a confidential matter that's there. What do y'all need? I can't hear you. Come on.
They're DVO, EPO case, but I don't have the docket. I wasn't sent a DVO docket. I don't know.
Do you have a domestic violence docket, do we? You want to come on up here and tell us what you got going on? And what's going on here?
We were just supposed to be back today we came, what, 2 months ago?
Yeah, what's your name?
Carly Martin.
Carrie Roden. Was there an EPO, DVO thing then, or what was there?
It was an EPO. You said you didn't really want to take it to a DVO or something.
Yeah, you got it against him? Okay, You pull that record up. I do remember it a little bit, but it's not, got slid off the docket here. If y'all just have a seat there, they'll bring a file up. We'll go off the record till then.